Oh, yeah, I did get. Wait a minute. I'm ready when you are.
Like a day-by-day slog.
Yeah.
Copy.
Yes, ma'am. Thank you.
Summary judge is appropriate.
It is 2 p.m., May 10th, and I call the Code Enforcement Board meeting to order. Madam Clerk, would you please call the roll?
Mrs. Archer?
Here.
Mr. Weeks is absent and excused. Ms. Dabbs?
Here.
Ms. Wade?
Here.
Mr. Kramer?
Here.
Mr. Robinson?
Here.
Ms. Norfleet?
Here.
That completes your roll call.
And I'd like to ask Attorney Trask if he would please give the invocation and lead us in the Pledge of Allegiance. Would everyone please stand?
Our Heavenly Father, send down your blessing on this meeting, the Code Enforcement Board. Give the board members a clear sense of duty and lead them to a faithful discharge of the same. Direct them in their deliberations at this meeting so that all things may be done to the glory of thy name and the welfare of the people of the city of Tarpon Springs. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I will now read the hearing procedures. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of the board goes as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will ask all potential witnesses to stand and be sworn in by the secretary of the board. So anyone that's going to be speaking or think they're going to be speaking, if they'd please stand and raise their right hand.
Do you swear the testimony you're about to give us the whole truth and nothing but the truth?
I do.
Thank you. Seated.
Under new business, number 1 has been deferred to the board. Number 2, it's case number 17-8000714 at 521 East Morgan Street, Thelma Stewart. Is there anyone here from? Would you like to come and have a seat at the? Would you please give us your name?
Kevin Jones.
Need to talk into the mic, please.
Kevin Jones.
And what is your relationship to the property?
My mother
Okay.
owns the property.
Okay. And I want to ask all board members to, if you're going to speak or make a motion, if you speak more into the mic so everyone can hear you.
All right.
Thank you. Officer Gasson?
Afternoon. Officer Gasson, City of Tarpon Springs Police Department, Code Enforcement. This is case 17-8000714. The property address is 521 East Morgan Street. Property owner is Thelma Stewart. Madam Chairman, exhibit number 1 going before the board are all the photographs to include my inspections. Exhibit number 2 are all my notices to include the notice of violation and notice of hearing. Exhibit number 3 are all my administrative documents, including the case summary, property appraiser and tax collector database, and any emails associated with the property. And exhibit number 4 is an affidavit of posting and a copy of the sign. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All of my notices were mailed to the property owner of record based on the Pinellas County Property Appraiser and Tax Collectors database via return receipt requested, certified mail, as well as first-class mail.
I need to ask, I got your name again.
Mr. Jones.
Cabin.
Mr. Jones, do you have
Yeah.
any objection to the city's documents and photos being
No
presented?
problem.
to
I
the
don't have a
board?
problem. I just need more time to get everything cleaned up and taken care of.
So then I'll ask the clerk to receive all the documents.
Yes, ma'am.
Thank you. The case originally started November 30th of 2017. Got a complaint about debris and stuff in the yard. Some of it was post-hurricane. Is kind of what started it. There was just a large amount of debris out front. There was a vehicle that fell under the classification of abandoned. I spoke to Mr. Jones, spoke to him a few times. He's in the process of trying to clean it up. He's still in the process of trying to clean it up. There's a significant amount of what's classified as debris, but trash and old equipment and things like that on the property. When I spoke to him, he had stated he had gotten sick, so that's the reason why it wasn't done by now. Moving forward, I conducted another inspection in January. There was minimal change. The vehicle was still there at the time. At that point in time, we issued a notice of violation, sent it via certified mail and first-class mail. Conducted another reinspection on February 23rd. Some of the front area was cleaned up. There was a fence installed to kind of secure some of the debris in the backyard of the house. Unfortunately, it's still visible from Diston and from Martin Luther King. The vehicle at that time was gone, so I complied that violation. A final notice of violation was mailed certified and first class on February 23rd. Conducted another reinspection. During that time, we'd talked to Mr. Jones and he asked for kind of an extension. That's the reason why it went from February to April. On April 5th, I conducted another reinspection. There's still debris in the rear yard. The notice of hearing was mailed on that date, certified and first class. On April 28th of this year, posted the property and the affidavit of posting was signed. I conducted a final inspection on the property yesterday, and basically there was very little change from the last inspection in April. We did get back, the notice of hearing was returned signed, the notice of violations were unsigned, and as I stated, we've had contact with Mr. Jones. He's been in contact with us. Before the board right now is simply a violation of 8-52, the nuisance prohibitions, which basically deals with cleaning up debris, unused equipment, unused materials, and the such from his property. And that's all I have at this time, ma'am.
Okay, does the board have any questions for Officer Gasson? Jones, do you have any questions for Officer Gasson?
No, ma'am. Like I said, I just need a little more time to get everything taken care of. I don't have a problem with cleaning it up. It's just, it's been accumulated over the years. My mom's owned the house since 1957, so over those amount of years, it accumulate quite a bit of stuff. So I am cleaning it up, and then the storm came and tore it up. So now we're dealing with the insurance company trying to get our roof taken care of and all sorts of things dealing with. So it's just been a little rough, but I will get it taken care of because I take care of my mom there by myself.
Does, supposed to ask questions for the board.
The board.
The board have any questions for Jones?
Mr. Jones, it's been about 6 months. About how long do you think you need to take care of?
I talked to Officer Gasson. I told him about 30 to 60 days, something like that. I should be able to have everything completed.
Any other questions? Officer Gasson, do you have any questions?
No, I don't.
Would you like to summarize?
No, I think I've covered that.
Would you have, is there anything else you'd like to
At this
bring
time,
before
no.
us? Okay. All right, so the public portion of this case is now closed, and we'll entertain a motion.
I'll make a motion. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Okay, any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Ms. Dabbs,
Yes.
Mrs. Archer,
Yes.
motion carries.
Okay, Officer Gasson, do you have a recommendation for time frame or?
Mr. Jones has asked for 30 to 60 days. I think it's reasonable to go with the 60 days, and he really doesn't have anything substantial with the city, so $25 a day after that point.
And you're okay with that, Mr. Jones?
That's fine. As long as I'm given time to taking care of it, ma'am, I'm sure I'll have it taken care of before the time. If not, I'll be in touch with Mr. Gatson to get in touch with
All right,
anything.
thank you. So we'll close this part as, forward and ready to entertain a motion on this?
I move that the respondent shall have until June 28th to bring the property into compliance with Code Section 8-52 or suffer a fine of $25 a day for each day thereafter that the respondents remain in violation of the code.
And second, you have a second?
Yes.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Ms. Dabbs,
Yes.
Mrs. Archer,
Yes. Okay, Mr. Jones, you have until, June 28th to get this all in compliance. After that, you will suffer a $25 a day, penalty. An order will be issued within 10 days and mailed to you. So it's important that you get this cleaned up.
Thank you very much.
Thank
Thank
you.
you.
Yeah, I'll get with her. Madam Chairman. Can we skip around a little bit?
Oh, sure, why not?
If you don't mind, let me find the case. It's going to be second to last. It's number 11 on your paperwork, 427 South Distant Avenue. They're here for that.
Okay, case number 18-800000211 at 427 South Distant Avenue, Marilyn Golden and Dorothy Archibald. Is anyone here to present? Like to have a seat and state your name, please?
My name is Marilyn Golden,
And what is your relationship to the property?
50% owner.
One of the exhibits.
Do you have any objections to the city's documents or photos being put in as evidence?
Really, a lot of this stuff has already been cleaned up, but and the window that they was talking about, they've been replaced. Well, I thought I had cut down and treated the stumps of all the pepper trees, but I guess
Well, you'll be able to state your case in a few minutes, but is it okay to present the,
yeah,
put them in as evidence, the photos for now, and then he'll explain.
okay,
You guys will explain them, okay?
all right.
So, Bob, if you'll receive those into evidence,
Yes, ma'am.
Officer Gasson.
Thank you, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case number 18-800000211. The address is 427 South Distant Avenue. The property owners listed are Marilyn Golden and Dorothy Archibald. Exhibit number 1 going before the board are all my photographs to include the inspections. Exhibit number 2 are all my notices to include the notice of violation and notice of hearings. Exhibit number 3 are administrative documents to include case summary, property appraiser, and tax collector records, as well as any emails. And exhibit number 4 is an affidavit of posting and a copy of the sign for the property. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violation and notice of hearings are sent certified mail, return, receipt, as well as first-class mail. This case initially started on April 5th of this year when myself and other members of the Tarpon Springs Police Department SWAT team executed a drug search warrant on the property at 427 South Distant. Based on the information from that under Sheriff's Office case numbers SO 18-81974 and Tarpon Springs case 18-8830, There were drug sales that were occurring on the property. Specifically, an Eric Washington sold crack cocaine to an undercover detective 2 times from the residence of 427 South Distant Avenue. Following the execution of a search warrant, additional crack cocaine was located in the residence, and Robert Earl Winwright III was charged with that cocaine. Also, marijuana was located inside the residence belonging to a resident named Damon Peters. Additional crack cocaine and marijuana were located inside a vehicle that was parked inside the fence on the property. And those charges are still pending as far as who's being charged with that. We had numerous tips about drug sales occurring on this property, and consequently, that's what stemmed the Sheriff's Office and the Pinellas County Task Force Narcotic Investigation into finally executing a search warrant on that property. In the process of executing that search warrant, since I'm also the code enforcement officer, I noticed numerous violations on the property, along with the nuisance violation that goes with the criminal acts that are occurring on the property. Also discovered there was some trash and debris being stored on it, specifically on the south side and the north side of the house. There was a hot tub, a bunch of other trash and debris. In the rear yard, there was trash and debris. There were broken windows. There were exposed wiring in the house, specifically under the front porch. There were numerous pepper trees on the property, and the fence was in poor and dilapidated condition. So, on April 9th, the notice of violation and notice of hearing was mailed certified and first class to the property owner. I did conduct a reinspection on April 26th. Significantly, there was no changes. On April 28th, I posted the property and an affidavit of posting was signed. And that was at the time my final inspection was on April 28th. The owner had contacted the office, contacted the office, but I hadn't specifically talked to her until today. She has attempted to bring some of the things into compliance, but I haven't had an opportunity to go out and do that final inspection. Speaking with her, it sounds like some of the issues are still there, specifically the fence, the trees, some of the trash and debris on the property. Based on the codes that are before the board, violations of 8-22, which is the accumulation of trash, 8-40 is the duty to maintain private property. That specifically is the nuisance aspect, which deals with the drug sales on the property. That's not occurring right now, so I mean, technically that's in compliance, but it's here before the board to be established under 840. But it also kind of ties in with the trash and the debris. It's a public nuisance. So until all those things are complied with, they're still technically open. 9-1 of Deer National Property Code was brought in, specifically section 604.3 for the electrical system hazards, which are the electrical wiring. Ms. Golden states that's been fixed, but I haven't personally inspected that. So until that point, it's still an open violation. Then 133.03 deals with the tree exemptions, which require anytime a certificate of occupancy has been issued to a property that the property owner continually maintains and does not allow any Brazilian pepper trees or other invasive species to grow or regrow on the property. And then finally, IPMC 304.13 deals with windows and door frames, which requires you to have intact glazing in your windows of your property. Those are the violations before the board at this time, and I have nothing further.
Board have any questions for Officer Gasson?
So is this property occupied?
Yes, by Ms. Golden and some other members of her family, I believe.
Do you have any questions at this time for Officer Gasson?
Well, the only thing is that when they bust in the house,
Is there going to be a question? Just a question, man, then you can, no questions at this time?
what can I say?
All right, then you can go ahead and state your case.
Well, at the time I'm gonna be honest. I'd be there. I lived there, true enough, and I didn't know nothing about no drug sales. So evidently, if anybody was selling drugs or Eric was selling drugs, he was doing it on the nights that I worked, cause I have a part-time job. I live off of my Social Security and my part-time money. And yes, there's some improvements that were being done in the process before they even broke in there, cause I got people working on the plumbing, cause I got old, what do you call it, galvanized piping. I got people working on that. So yeah, there is a lot of debris, cause they take down walls and stuff like that. But that stuff was bagged up, and a lot of it has been moved. The hot tub thing that he talked about, that's a shower stall thing that was supposed to be installed in my shower, and I don't have a shed, so I had it on the side of the house behind some trees. But I'm taking care of everything that I can. Like I say, I have limited resources as far as money is concerned. I'm doing my best, and I did ask him if I could have 60 more days. I don't know with the fence situation right now. I bought pieces and parts, but I asked him if he would come out and let me know whether what I'm doing is the right thing, because I'm doing this myself. I went out there and put the pieces in. I'm doing this myself. I don't have the money to hire a fence company. They want $1,700, and they said they would refurbish the whole fence plus draw some kind of permit. I don't have that kind of money to give out at no one time, and people are not taking payments for stuff. I spent like $3,000-4,000 cleaning up from when the hurricane came and blew down a lot of trees around the house. And I'm just doing the best I can with what I got. And the drug business, I don't know nothing about it. Y'all can test me from now to New Year's. I don't do no drug.
The board have any questions for? No questions? Officer Gaston, do you have any questions?
No, I do not.
Would you like to summarize?
No, I think I've covered it. Thank you.
Is there anything else that you'd like to say?
I just would like to get some extra time. I live off of with my part-time job and my Social Security check. I live off of $2,300 a month. Out of that, I have to pay, bills. But I'm doing the best I can as to fix what he told me, because before, when he said something wrong with the fence, I did a little something, but I didn't do what I'm doing now because I didn't have the funds. I really don't have them now, but, I'm doing it a little bit at a time.
So the public portion of this case is now closed, and we'll entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-22, 8-40, 8-52, 9-1, 36.03, 133.03, and IPMC 304.13 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Have a second?
Second.
Any discussion?
Yes. My concern isn't the violations as much as the reported drug activity.
Need to speak.
Yeah, my concern is not the violations. We can give them 60 days or 90 days. My concern is the drug activity. That I heard what she said, that it's not, she didn't know about it. I'm not sure I can buy that.
But I'm telling you the truth, sir.
And that's my concern, is this one of those places that's going to continue to be drug active? I don't mind giving them 90 days to clean up. I understand her situation. But drugs,
Well, all I can do
give you
is
5
put
minutes to not have drugs around. That's my input.
Is anyone else?
Do the people who've been charged with these
No.
crimes still live at that residence?
No, they.
Yeah, we're
they-
closed.
Public
he never.
portion's closed.
Eric Washington never.
Hold on. Yeah.
I was out of order, I'm sorry.
Public portion was closed. Yeah.
Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Ms. Stabs,
Yes.
Mrs. Archer.
Yes. Officer Gaston, do you have a recommendation for time frame compliance or daily fine?
you know, she requested the 60 days, and she doesn't have a significant prior history with the city, so I would say $25 a day for that part. The rest of it will become established, so we'll deal with that if it occurs again.
Do you have any input for that?
Well,
60 days?
they told me, said that the put what do you call it, trespassing warrants or whatever on people on the property. I'm in the process of getting that done.
Yeah, but
And
you're
I'm
okay with the
posting,
60
and
days?
I'm
Yeah,
posting.
Okay with the 60 days for compliance?
Yes,
Okay, all right.
I wish I could have got the 90, but thank you for the 60.
Ready to entertain a motion?
I move that the respondent shall have until July 10th to bring the property into compliance with code sections 8-22, 8-40, 8-52, 9-1, 36.03, 133.03, and IPMC 304.13, or suffer a fine of $25 per day for each day thereafter the respondents remain in violation of said code sections.
Have a second?
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Mr. Wade,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes. Will you explain for it?
Yeah, I'd have to. So, Mrs. Golden, are you? You've been given 60 days, which is, well, until July 10th, to bring the property into compliance. Once you've brought the property into compliance, you need to call Officer Gasson for him to come out and inspect. So don't wait until the 60 days is over with to do that. You can call him at any time that it's ready. Once the property is in compliance, there'll be no further activity on your part that you'll be required to do. But if you don't bring it into compliance by July the 10th, the fine begins to run at $25 a day.
Yes, sir.
If you have any questions about what happened today, call the Code Enforcement Department tomorrow, and they'll be happy to explain it to you.
Oh, all I needed was the date, and you repeated that
Yeah,
for me,
July
sir.
10th. Okay, thank you.
Thank you all very much. God bless.
Where are we going now?
We're going to number 8, 445 Martin Luther King.
Where are we going?
Number 8.
Number 8. Yeah, case 181.
Number 8.
Okay.
This is case number 18-800000181 at 445 East Martin Luther King Jr. Drive, Carrington Mortgage Loan Trust. Is there anyone here? Oh, okay. Would you state your name, please?
My name is Joseph Baring, and this is my mother's boyfriend, Roy Duranda.
And what is your relationship to the property?
We are in process of trying to change the
The-
mortgage and everything over into our
The
name.
previous mortgagee was a friend, like a friend for a long time in the family. We've known them for years, and the daughter, who is now the
Executive.
current executive of the property, is now signing the property over to us.
Okay, these people have no ownership interest in this property. They are not the owners under the law, and so they should not be speaking on behalf of Carrington Mortgage Loan Trust. And so if Mr. Gasson wants to call them as witnesses, then he can call them as witnesses. Otherwise, you are not parties to this law, to this code enforcement action, even though you may live there.
Okay.
So you can still be seated there, but you will not be able to present any evidence, okay? And you will not be able to cross-examine or ask any further questions.
Well, can I ask one thing?
Sure.
Because most of the things that we're asked to be taken care of, I have pictures that they were. So I was wondering if I could
No,
show
you're not
that
a
those
party
were-
to the lawsuit or to the code enforcement action, so no, you're not going to be presenting evidence, okay? Only,
Okay.
okay. So, but you can provide that information to the code enforcement department tomorrow or after this meeting,
Okay.
and that may,
Can I get his phone number like afterwards?
yes, Officer Gasson will be happy to give that to you, so,
Thank you.
okay.
Okay, Officer Gasson?
Officer Steve Gasson, City of Tarpon Springs Code Enforcement. Case number 18-800000181. Property address is 445 East Martin Luther King Jr. Drive, As stated, the property owner is Carrington Mortgage Loan Trust. Exhibit number 1 going before the board are all of my photographs to include the inspections. Exhibit number 2 are all of my notices to include notice of violation and notice of hearing. Exhibit number 3 are any administrative docs to include the case summary, property appraiser, and tax collector records, and emails that were exchanged between our office and the property owners. Exhibit number 4 is the affidavit of posting and a copy of the sign. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All notice of violations and notice of hearings are sent via certified mail, return receipt requested, as well as first-class mail. And Madam Chairman, if you would please accept all those exhibits into evidence of the record. We good?
Yep.
Okay. The case originally started March 15th. There's a large amount of trash and debris all over the property, front and rear, including furniture, trash, and other debris. The interesting thing about this case, I had a prior case on this property, but that resident had died. So started a new case. It looked like everything from inside of the house had basically been dumped outside of the house. That's what spawned the case. And on March 16th, I sent a notice of violation via certified and first-class mail. Conducted a reinspection by nature of the fact that I responded with other patrol officers to a domestic that was occurring inside the house. When I responded to that call, I entered the house through the back gate area where I happened to notice a inflatable pool that was filled with about 2 feet of very green water, as well as a large amount of trash and debris inside that fenced-in area on the back side of the house. Basically went through a whole bunch of things trying to figure out ownership because I side jobbed it a little bit and was trying to figure out what the status of the house was. It was basically boils down to Carrington Mortgage owns it flat out, right? There's no other documentation of any sort showing any other type of ownership other than Carrington owns it. I conducted a reinspection on March 31st, and basically there was no change. Admittedly, I hadn't been back inside that fenced area I spoke of before because I hadn't been invited back on the property. On April 2nd, the notice of hearing was mailed first class. Our office has been exchanging emails back and forth with a representative of Carrington Mortgage. They flat out said, sorry, the house is occupied. We won't do anything about it.
Repeat that, please.
Carrington Mortgage, the company itself, their management company has basically told us in emails, which are included with the case, that because the property is occupied, they won't clean it up. It's quote unquote their responsibility. So needless to say, that's as far as I got with the mortgage company or the property owners. So at this time, before I conducted my final inspection yesterday, there was some cleanup of trash outside that I could see, but once again, like I said, I can't see inside that fenced-in area. And if the tenants want to after this, if they want to invite me on the property, they can make an appointment and I can inspect that area to see if there is compliance with that. But at this point in time, as I stated, I still don't have any reason to believe or any evidence that they are not in violation of 8-22, which is the accumulation of trash, 8-40, which is the nuisance and the duty to maintain private property and any of the nuisance conditions, specifically dealing with that pool. Even though it is inside of a fenced area, it's still a nuisance. And 8-52, which is debris and trash and of the sort on the property. And that's all I have at this time, ma'am.
Anyone have any questions for Officer Gasson?
Nope. Yep.
Okay, the public portion of this case is now closed, and we will entertain a motion. Still looking at the page. Okay, we need a motion.
Let me do it. I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, section 822, 840-852 of the Code of Ordinance of the City of Tarpon Springs was not enforced. The respondent were in violation thereof.
Second.
Wait,
Well,
she accidentally said was not enforced.
Yeah,
Wasn't.
We need the motion to reflect that these code sections are currently in force. If they're not in force, you can't make a finding of violation, so, we either need to redo the motion,
Misspoke.
you
I
said
said
not
was.
in force, or they are in force.
Was, yeah, was enforced in effect.
Okay,
The respondent was over in violation there.
okay. Madam Chair, that's a good
Need a second?
motion.
Second.
Any discussion? Roll call?
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Ms. Dabbs?
Yes.
Mrs. Archer?
Yes. Officer Gaston, do you have a recommendation for time frame or daily fine?
30 days and $100 a day.
100.
30 days and $100 a day. Maybe that'll motivate the mortgage company to take care of their property.
Motion?
Is made.
I move that the respondent shall have until June 11th to bring the property into compliance with the code sections 8-22, 8-40, and 8-52, or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said code section.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Thank you. Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Archer?
Yes.
I just want to make sure that the residents understand. So the mortgage company has been found in violation, or the owner has been found in violation. The mortgage company has been given till June 11th to come into compliance, so they're going to be fined $100 a day. So that's what this board has decided. If you want to be involved in getting the property cleaned up, like I said, you can talk to Officer Gasson after the meeting.
Yeah, so we would just need the officer's phone number.
Okay,
And
so
then-
you can talk to Beth over here, so they'll give you the phone number, and
All right.
you can call in after the meeting.
All right, because
Okay.
that's no problem. We already took care of all this. Like I said, we didn't know what to do after that, and so we came here trying to see if we could see what we can get done. But if
Thank
we
you.
can't do anything until Carrington sets everything up to us, then that's fine. Like I said, it's just a waiting game with them too, because they have to go through the daughter, who lives in like another 2 states.
In Alabama. But
So-
CMC is the company that is the property maintenance.
So we understand. We already got most of it up, and we would be more than happy for the officer to come up and like see that the rest of it is up to date.
All right, thank you.
Thank you.
Thank
What
you.
I was trying to explain is,
What?
the bank.
You
is at their
you don't
property.
need to,
Oh, it's okay.
it doesn't
Good,
matter.
Thank you.
Thank you.
We're done.
I know.
Thank you.
All right, we're back in order. Number 3,
Nina, you got it.
435 East Lemon Street. And she's here in the
Number
back, and I
3.
believe she has to be sworn in.
Where are we
ma'am.
going?
Oh, going back.
Number 3.
Yes, we're going to
Here
number
comes up.
Okay.
Just
Okay.
wondering.
Case number 18-8000071, 435 East Lemon Street. Hector, Ina, Elaine Navas.
She needs to be sworn. Okay.
Ms. Navas, do you need to be sworn in?
Yes.
Hi. You just want to stand and raise your right hand?
Do you swear the testimony you're about to give us the whole truth and nothing but the truth?
Yes.
Thank
Okay.
Do you have any objection?
That would be nice, yes.
Do you have any objections to city documents or photos being run in for evidence?
Do I have objections?
Any objection? Is it okay to? We have city documents and photographs.
Yes. They're old, though.
Do you have any objection?
What do you mean objections? These are not,
Is it okay if we pass them?
if
Let
you,
let me just explain to her. Okay.
Okay.
So the city is going to tender those documents into evidence, whether they're photographs or documents.
okay.
Okay, you're being asked by the chairman whether or not you have any legal objections. If you don't have any legal objections, it will be received into evidence. If you do have legal objections, you need to tell the chairman at this point what your legal objections are. Not that the property has changed and is different since a photograph was taken. That's not a legal objection.
Okay. Then I have no legal objection.
Okay, thank you.
Thank you.
Tell Bobby to receive them.
Bobby, will you please receive these into evidence?
Yes, ma'am, I will.
Officer Gaston?
Thanks, Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case number before the board is 18-800000071. The property address is 435 East Lemon Street, owned by Hector, Ina and Elaine Navas. Exhibit number 1 going before the board are all of my photographs to include my inspections. All of my notices to include the notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are any administrative docs, include a case summary, property appraiser and tax collector database, and any officer emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And Madam Chairman, all of my photographs and exhibits that were given to the violator are exact copies of what was presented to the board. All the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. And all notice of violations and notice of hearings were sent certified return receipt as well as first class. And ma'am, I believe you already accepted them into the record. This initially started back in February of 2018. I was inspecting neighboring properties, and I observed violations on this property, namely a red Jeep with no tags in the rear yard, numerous rusted wheelbarrows, old riding lawnmower, which appears inoperable and unused, other trash and debris on the property, and a chain link fence along the alleyway that was in very poor and dilapidated condition. Sent a letter out on February 12th, conducted another inspection on March 23rd. Basically, there was no change at that point in time, sent out a notice of violation. April 13th, conducted a reinspection. Basically, still no change. Did receive an email asking for more time, but no specific time frame was given. So we, at that point in time, put it on the, sent a notice of hearing for this code board. April 17th, the notice of hearing was mailed first class and certified. On April 28th, I posted the property, and I conducted a final inspection yesterday. The fence has primarily been taken down with the exception of some posts. And my understanding is that they left the posts up because they're attempting to replace the fencing, the chain link material, and reuse the posts. The Jeep, as of yesterday, had flashing lights and was on a charger. So I don't know. I haven't had an opportunity to go by today and see if the Jeep is still there or if it's tagged and then operable, which is perfectly fine there. The wheelbarrows were no longer stacked up along the side of the shed. And the only thing I saw that remained yesterday was the old lawnmower, the old riding lawnmower. So at this point in time, 8-40, duty to maintain private property, the nuisance prohibitions, which are debris, which is classified as old unused equipment, and a myriad of other things. As of my last inspection, as I stated, the red Jeep was still there, so 40.00 was still in effect as of May 9th. And then the fence is technically under the code. You can't have posts with no fencing. So, but they're working on that. So I have a feeling we're going to hear that discussion in a minute about those. But those are the 4 violations before the board. And that's all I have, Madam Chairman.
All right. Board have any questions for Officer Gaston? Thomas, do you have any questions at this time for Officer Gaston?
Not questions, but statements to say that the red Jeep is
Just
gone.
questions at this time.
Oh, just questions?
Any questions for Don?
No, no.
Okay, all right. Then you can go ahead and state your case.
That the red Jeep is gone, and so is the lawnmower, and that's it. The fencing I did not know until I talked to Beth about it today, but we are hoping to recreate the fence more like a green Confederate jasmine fence, not just a chain link with a green fence instead of metal. And we should do that within, hopefully, if the irrigation gets working again, 30 days.
Does the board have any questions for Ms. Navas? Ms. Navas?
Do you feel like you can satisfy all of that in 30 days? Is that what you're?
Yeah, I guess the poles would be the last thing. Everything else is gone. And I went down Lemon Street today and saw some other places where they had rope with the fence, and I did not know that that was an alternative to a fence, but no, we're hoping to get a green fence. That alley is very dusty in the summer, and something to block the dust from coming on the property is good.
Any other questions? Officer Gaston, do you have any questions?
No, I do not.
Would you like to summarize?
No, I don't need. Thank you.
Do you have anything else you'd like to summarize?
No, are there any questions, other questions?
I don't think. Okay. This portion of the case is now closed then, and we'll entertain a motion.
I move based on testimony, evidence, and facts presented in law that at the time of the alleged violation, sections 8-40, 8-52, 40.00, and 36.03 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Ms. Dabbs,
Yes.
Mrs. Archer.
Yes. Officer Gaston, recommendation for time frame or?
30 days, and then we've had very limited, we had one prior case many, many years ago with that property address. I don't even know if it's the same owner. So I would say $25 a day. And it sounds like she's primarily done anyway.
Okay. Do you have any input on the compliance date or the daily fine?
Nope.
Let's entertain a motion. Go for it.
I move that the respondent shall have until July 10th to bring the property into compliance with code sections 8-40, 8-52, 40.00, 36.03, or suffer a fine of $25 per day for each day thereafter the respondents remain in violation of said code sections.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes. So, Ms. Novice, you have until July 10th to bring all this into compliance. It sounds like you've gotten pretty much a lot of it done now. Or after the 10th, you will suffer a $25 a day. So you want to get it cleaned up. And an order will be issued and mailed to you within 10 days.
Okay.
Okay.
Just wanted to make note that on Lemon Street, we have a box of mail, and a lot of time our mails get switched. So I never got a February one. I get Mr. Lontakis's mail all the time in my box, so I don't know what we could do to,
I'm going to check with the post office. Have you done that?
well, it's in someone else's box. They're
Let them know.
gonna have to work with the
Okay.
mail on that.
All
Thank
right,
you.
Thank you.
Should be on number 6. 601 MLK.
Number 6.
And
On my board. Okay, case number 18-800000113. It's 601 East Martin Luther King Jr. Drive. It's Deanna Ruth Gorham. Is anyone here for this case? All right.
okay. Officer Steve Gaston, City of Tarpon Springs Police Department Code Enforcement. Case before the board 18-800000113. Address 601 East Martin Luther King Drive. Property owner Deanna Ruth Gorman. Madam Chairman, exhibit number 1 going before the board are all my photographs to include the inspections. All my notices to include my notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are any administrative documents, including the case summary and property copies of the Pinellas County Property Appraiser and Tax Collector databases, and any emails regarding this property. Exhibit number 4 is affidavit of posting and a copy of the sign. All my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector records and databases. All the notice of violations and notice of hearings were sent, both certified mail, return receipt requested, as well as first-class mail. And Madam Chairman, if you would please accept all these documents into the
Yes, we
record.
will. Bobby Phillips.
Case started on March 3rd of this year. Originally got a complaint about 2 vehicles on the property with no tags. I inspected it and found such: a red vehicle missing a front bumper with no tag, and then a silver, I believe it's a Mercury, parked in front of it on the east side of the property as well with no tag. On March 5th, we mailed out a notice of violation, both certified and first class. I conducted a reinspection on March 21st. Both vehicles are still on the property with no tags. April 12th, the notice of hearing was mailed. April 28th, I posted the property and signed the affidavit. On May 9th, I conducted the inspection, and there's 2 vehicles are still there. Had no contact with the property owner, and all of our mail's been returned unclaimed or undeliverable. Before the board are 2 counts of 40.00 parking storage of abandoned vehicles, that being the red Chevy and the silver Mercury. And that's all I have at this time for the board.
Okay, does the board have any questions for Officer Gasson? Anything you'd like to summarize, Officer Gasson?
I did have one.
You do have a question, go ahead, I'm sorry.
Is this at a residence or is this a vacant?
It's a residence, right at the corner of Martin Luther King and Diston where the flashing light is.
Anything else?
I don't have anything.
Summarize? Okay, we're ready to entertain a motion.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, Section 440.00 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Archer?
Yes. Officer Gasson, recommendation of time frame, daily fine?
Yeah, I'll pose this to the board. This property is already accruing daily fines for different violations under a 2017 case. We just opened up another active 2018 case for, it's a visibility triangle that has to deal with a tree in the front yard. Based on the fact that we seem to have a significant issue with this property, I would say probably 10 days and $250 a day.
Yes.
Okay, entertain a motion.
I move that the respondent shall have until May 24th to bring the property into compliance with Code Section 40.00 or suffer a fine of $200 a day. For each day thereafter, the respondent remains in violation of the said code section.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Archer?
Yes. Number 9.
Number 9.
Case number 18-800000190 at 621 North Avenue. Julie Brenna Smith. Is there anyone here? All right. Officer Gasson, go.
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. Case before the board is 18-800000190. Property address 621 North Avenue. The property owner's name is Julie Brenna Smith. Exhibit number 1 going before the board are all of my photographs, including my inspection photographs. All of my notices, to include the notice of violation and notice of hearing, are exhibit number 2. Exhibit number 3, any administrative documents, including my case summary, property appraiser, and tax collector database, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. All of my notices were mailed to the property owner, a record derived from the Pinellas County property appraiser and tax collector databases. All my notice of violations and notice of hearings are sent via certified mail, return receipt requested, as well as first-class mail. And Madam Chairman, please accept all these exhibits into the record as evidence.
Yes, Bob, if you would do that document, please.
Yes, ma'am.
The case started March 30th of this year. Got a complaint about a couple of properties in that area of North Avenue. There was an old scooter, appears to be unused, as well as an unused jet ski. There was a white Pontiac backed in, and some other debris in the front yard. Sent a letter on March 20th, conducted a reinspection on April 5th. There was no change at that point in time, sent a notice of violation, which was sent on April 5th. On April 18th, we amended the notice of violation because originally I'd forgot to put in the white Pontiac, so we amended it, sent a new violation, or amended notice of violation out for the vehicle. Notice of hearing was sent on April 18th, and I conducted a reinspection on April 19th. The jet ski is still there, and there's like a grill, and the scooter was still there at that time on the north side of the property. On April 28th, I conducted another inspection, and the scooter and the Pontiac are gone, so I closed those violations. The jet ski is still on the south side of the house. The barbecue grill and a couple of tires and things are still on the north side of the house. The property was posted on April 28th. Conducted the inspection, a final inspection yesterday, and as I stated, the jet ski, the barbecue, it looks like a 55-gallon drum is kind of sitting there on the north side of the house by the fence. You can kind of see it in one of the pictures. I've had no personal contact. They did leave a message, but we're unable to call them back because it was like a hospital number, so it was generic on our caller ID. So we've technically had no contact with the property owner. Before the board at this time are violation 8-52, the nuisance prohibitions for basically the debris. The jet ski appears to be unused equipment, so it falls under the definition of debris, as well as the rather rusty barbecue or smoker or whatever the 55-gallon drum thing is on the north side of the property. And that's all I have before the board, just the violation of 8-52.
Board have any questions for Officer Gasson?
I did have a little question. It's procedural. Do we need to separate these issues then if the one says complied?
Are you moving forward on the one that's compliant?
It's 852.
Okay.
Yeah, the complied ones I'm not moving forward
Yeah.
with.
So he's only asking for a violation to be found on 852, so there's only one at this
Okay,
point.
thank you.
Yeah.
Any other questions? Anything you'd like to summarize? Officer Gasson?
I have nothing further.
Public portion of this case is now closed, and we can entertain a motion.
I move that, based on testimony, evidence, and facts presented in law, that at the time of the alleged violations of Section 8-52 of the city ordinance of the Code of Ordinance of the City of Tarpon Springs was in force and effect, the respondent was in violation thereof.
A second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes,
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes. Officer Gasson, recommendation for time frame or daily fine?
30, we had really no priors. We had absolutely no priors with that property, so we've stretched it out for a little while, so I would say 30 days and $25 a day.
Make a motion, please.
I move that the respondent shall have until June 12th to bring the property into compliance with code section 8-52, or suffer a fine of $25 per day for each day thereafter the respondents remain in violation of said code sections.
Second, any second to the motion?
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes,
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes. Going to 12. Case number 18-8000227 at 1700 Blue Lake Court. Pamela Traw.
Draw.
Is there anyone here for this case? Okay, Officer Gasson, go ahead.
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement, case before the board 18-8000227. The property address is 1700 Blue Lake Court. Pamela Traw is the listed owner of the property. Exhibit number 1 going before the board are all of my photographs of my inspections. All the notices and notice of violation and notice of hearings are exhibit number 2. Exhibit number 3 are any administrative documents, case summary, copies of the property appraiser and tax collector database, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And all of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector databases. All my notice of violation and notice of hearings are sent via certified mail as well as first-class mail. And Madam Chairman, if you would accept all those into the record as evidence.
Yes, Bobby, if you put those in evidence, thank you.
Case originally started based on a citizen complaint on April 7th of this year. It's a stack of boxes out in front of the house. This is an ongoing issue. I actually had a prior case for the exact same thing. It appears she just continually gets deliveries and they're stacked up out in front of the house. What was different about this time from my prior case is she installed some sort of like shutters or something in her front patio area. So there was boxes stacked up behind that. that you could see through the opening in them. And there was also a couple of trash cans out in front of her garage that weren't stored properly. At that point in time, I decided to go ahead and bring her before the board to have her established for those violations. She's still in violation, but my intent was, regardless, was to bring her before the board. So for that reason, on April 9th, we sent a notice of violation and a notice of hearing to come before this board. We sent certified mail as well as first class. On April 25th, I conducted a reinspection. Some of the boxes were picked up from in front of the shutters, but you could still see them stacked up clearly behind the shutter material. On April 28th, I posted the property, and an affidavit of posting was signed. On May 9th, I conducted another inspection, and as I stated, there's still some packages stacked up behind those doors, clearly visible from the roadway. We did get a phone call from the owner. I don't know exactly what the results of that were, but as I stated on May 9th, yesterday, we're still in violation. In regards to 8-16, which is the pre-collection practices of the trash cans, when I saw it the other day, it was trash day, so I kind of don't take that into account. So I would say it's still in violation as of today. If nothing else, it'll be established by this board. It would be my intent. And then 8-40, primarily under the duty to maintain property and the nuisance conditions, those definitions under 8-38 and 8-41 are encompassed by 840. One of the very first conditions of nuisance conditions under our ordinance is a condition or use that causes a substantial diminution of property value or property in the vicinity of the condition of use. And basically, this has been kind of constant neighbor complaints. I've seen it pretty substantial where the boxes are just stacked up. She's had meat delivered and it's gone rotten out in front of the house. I think that's a fair statement based on these property owners. A couple of them actually put their houses up for sale, that it falls under that definition under 838, or I'm sorry, under 841 subsection A. So for that reason, like I said, there's still boxes there. So in my opinion, it's still in violation. So before the board is 8-16 and 8-40, the duty to maintain private property and the nuisance conditions.
Board have any questions for Officer Gasson?
Yes. You note you had a phone call from her, with her. She called you, you called her?
She called the office. I've never spoke to her.
Okay.
And I didn't get anything further from Beth as far as
therefore you don't know what she
anything
said when
substantial, correct?
Okay. Okay.
And I have a question.
Yes,
She
ma'am.
does live there?
She does live there, yes. I've been inside the house a few years ago, so she does live there.
All righty, we'll close this public portion then and entertain a motion.
I move based on testimony, evidence, and facts presented and law at the time of the alleged violation of section 8-16 and 8-40 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. The respondent was in violation thereof.
You have a second?
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Mrs. Wade?
Yes.
Mrs. Dabbs?
Yes.
Mrs. Archer?
Yes. Recommendation or time frame, or Bailey?
You know, as I stated, there was one prior in 2015. It was the same thing when I first started in code enforcement. It was pretty substantial at the time. In all honesty, in my opinion, it seems to be a hoarding issue because, as I stated, I'd been out that property. We did a welfare check because of the smells that were coming out of the house. We actually forced entry into the house, and the garage was, the house was stuffed with stuff. So it's going to continue to happen, but I'd like to see her at least be able to get that front part cleaned up within the next 30 days. And I think probably in this case, a reasonable fine, because she's only had the one other violation back in 2015 is like $50 a day. The board's establishing her, so I have a feeling it'll probably be revisited. I'm hoping it won't be, but I have the odd feeling it'll probably be revisited here in the near future. So I think it's going to become a chronic problem. So maybe we can stave it off.
Okay. Somebody like to make a motion?
I move that the respondent shall have until June 12th to bring the property into compliance with code sections 8-16 and 8-40 or suffer a fine of $50 a day for each day thereafter the respondent remains in violation of said code section.
Second.
Any discussion? Roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes. Okay. Now we're going to number 13.
Yes,
Re-
number 13.
Repeat violator in violation of, from 12/22/2017 to 3/5/2018 for 73 days. It's case number 17-8000772 at 439 East Lemon Street, the Annexi Group LLC. So when you can, if you'll state your names, please, and your relationship to the property.
Mary Annexi, I own the property and I rent it out.
I'm attorney Daniel Rock. I represent the Annexi Group.
You're hard to hear, sir.
Daniel Rock, I represent the Annexi Group LLC. I have some additional witnesses that we'll call when we need to.
We're ready.
Officer Steve Gasson, City of Tarpon Springs Police Department Code Enforcement. The case before the board is case number 17-800000772. Property address is 439 East Lemon Street. Property is owned by the Annexi Group LLC.
Do we have documents or photographs we're sending out? Okay, I need to ask, do you have any objection to the documents or photographs we have to be?
Yes, in as much as we have an initial charge in December 22nd of 2017. Officer Gasson goes back and, without amending the complaint, takes photographs of other things that are dumped alongside the property, which my client has to clean up. And so obviously there's a termination date as to when the things that were my client was charged with and got the clearance many days later. I mean, two and a half months later. So not as to the original photographs, yes, as to the photographs taken on and after January 10th, 2018.
I'll let Mr. Gaston for that.
Yes, he needs to respond.
Mr. Gaston, you want to respond?
Well, basically, December 22nd, we conducted the inspections. It's not unusual for me to go back and take photographs at a later date. As far as that goes, a lot of times those, as council states, additional charges are just additional information under the original charge. 852 is rather broad, 840 is rather broad. So, trash and debris, and you notice it on another side of the house when you take photographs, the original's still there. So, based at the time the violations occurred. Also, going forward with that, as property gets cleaned up, sometimes new things are discovered. So there was significant cleanup done over a period of time on this property, and other things were discovered. So that may explain that. I'm sorry.
Madam Chair, you need to either sustain the objection or overrule it. The objection made by Mr. Rock is legal objection of relevance. And so you need to decide whether it's relevant to the case or not, the photographs that he's asking to be not
I
received.
believe they are, and I'm going to overrule it.
Okay. Anything else, Mr. Rock?
Not until I'll do it when I'm a cross-examination.
Yeah, you have the right to
No,
cross-examine.
no
Okay.
other objection.
Okay, so Bob, if you will put those in the evidence, please.
Yes, ma'am.
And Officer Gaston, when you're ready.
Thank you. As I stated, Officer Gaston, City of Tarpon Springs Code Enforcement, the case 17-800000772. All of the photographs that are presented to the board include my inspections. Exhibit number 2 are all of my notices, to include the notice of violation and notice of hearings. Exhibit number 3 are my administrative docs, to include the case summary, property appraiser and tax collector records, and any emails. Exhibit number 4 is the affidavit of posting and a copy of the sign. And exhibit number 5 is the affidavit of prosecution costs for the case. All the photographs and exhibits that were given to the violator are exact copies of what's being presented to the board. All the notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collector database. and I believe you already have, but if you would, please accept all those items into evidence for the record. As Mr. Rock stated, my initial inspection was December 22nd of 2017 of the property at 439 East Lemon Street. Originally, I was conducting an inspection on a neighboring property. Post-hurricane damage, there had been some tree damage in that alleyway on Lemon Street. That also stemmed from the previous case I talked about at 435 East Lemon, which is directly next door to the west of this property. I discovered numerous violations. There was Brazilian pepper trees on the property. They were obstructing the alley to the north and making it difficult to get through the right-of-way. There was also a Mercury vehicle parked in, which appeared to be inoperative. I was unable to see the tags or confirm the registration validity or operability. There was other trash and debris on the property which needed to be cleaned up and mowed. The fence was in poor condition. Fence on the east side was like an agricultural type of fencing, not a typical residential type fence. It was kind of like it was like a mesh material, as you can see in the photographs, and it was also in poor condition. Now, this property originally became a repeat violator for a couple of prior cases. Initially in 2015, under case 15-391, this particular address, 439 East Lemon Street, was in violation of 8-40, which is one of the violations brought before the board today. Also, 199 Grand Boulevard in October of 2017, under case 17-481, was in violation of 8-40, heard before this board. So under case number 17-618, 8-40 and 8-52 were heard before this board November 2017 for 39 West Oakwood. All three of those properties listed are owned by the Annexi Group. So moving forward, Ms. Annexi came in on January 2nd, clarify some of the violations, and then we started in, she contracted or hired an attorney at that point in time, so we had some legal things. Eventually, on January 12th, I met with Ms. Annexi on the property, explained to her what the violations were, what was going to need to be done to be brought into compliance, and she began working on those violations. On January 25th, I conducted a reinspection. On inspection, there's still debris in the backyard, including broken furniture and a pile of yard debris and a pile of wood. The fence along the east side and west side's been removed, so that violation is in compliance. A number of pepper trees remain, have not been removed. They were cut off, with some being over 4 feet tall. As the code requires, the trees have to be removed and regrowth prevented under 133.03. There's no evidence of chemical application to prevent regrowth. January 26th, the property was posted and an affidavit of posting was signed. On January 30th, I conducted another reinspection, still not in compliance. There's broken furniture out back. There's still a pile of wood debris. There's tires, and there's debris and trash inside of a small fenced-in area that you can see inside the photographs. On February 7th, conducted another inspection, checked the property, and there's still tires, stack of wood, cement pieces, broken furniture, and debris inside the wooden fenced-in area. The pepper trees are not showing any regrowth at this time. I believe Ms. Annexi had stated, and I can't remember all of our conversations, that they may have been treated. I have nothing else to say they weren't. So at that time, February 9th, we got a deferral notice, which was mailed certified and first class at the attorney's request, and we began to postpone these board cases until now. Reached out to Ms. Annexi on February 14th to let her know the only violation left was some debris. We attempted to schedule an appointment and get that taken care of on February 15th of 2018, and she wanted an appointment. We met, and then she stated on that date that it was ready for a reinspection. So on February 16th, I was asked to reinspect. The only change I noticed is that the 2 tires were removed. There's still a stack of old wood, cement pieces, and broken furniture still on the property. So at this point in time, still not in compliance. And I added some new photographs at that point in time. February 16th, we got an office call from Mary Annexi, and we told her that the property was still not in compliance. On February 20th, she said the property was ready for reinspection. On February 28th, she was asking if it was in compliance. On March 2nd, I went and re-inspected, It's still not in compliance. There's still cement pieces on the property. March 2nd, we let her know the cement pieces need to be removed. Beth had called Mary to let her know the cement pieces need to be removed and bring the property in compliance. Also reminded her to call as soon as it was completed. She stated she would have the cement pieces removed and would call when completed. On March 5th, she called to state the property is ready for reinspection. On March 6th, it was in compliance. So we backdated to March 5th because that was the date she called to said it was in compliance. So finally, on March 5th, the property was in compliance. March 31st, we posted the property. We got an email from the attorney requesting a continuance, so we did. And finally, we are here before the board on this date after some continuances for a violation of 8-40, duty to maintain private property as a repeat violator, 8-52, 40.00, the inoperable vehicles, the White Mercury, 13303, which is the tree exemptions under the requirement that a building with a certificate of occupancy can't have any invasive species, 8-22, which is the accumulation of trash, and 36.03, fences, walls, and hedges, which require that you maintain your fences. Now, all of those are in compliance. So, she was a repeat violator, as I stated, for the previous cases, for a total of 73 days, from December 22nd of 2017 until March 5th of 2018. And at this point, that's all I have for the board.
Does the board have any questions for Officer Gasson?
So only the two items, 8-40 and 8-52, are those that were in violation for that period of time?
That is correct. They're the only ones that are subject to the repeat violator status. The other ones are all in compliance, but I'd like the board to establish all those other violations.
Any other questions?
Do we have the paperwork to establish those numbers?
It would be in the notice of violation.
We don't.
So wherever the packet of materials is, if you want to look at that, Bobby can send it back to you, but it would be in the notice of violation in that packet of materials.
And actually, I think I'm going to stand corrected because I don't believe we sent out a notice of hearing for the other violations. So the only ones we're concerned with are 8-40 and 8-52.
Okay.
8-40 and 8-52 are the only ones, and they're in compliance, but they're the only ones under the repeat violator status. I won't be establishing the other ones because we did not send a notice of hearing stating that we're going to go forward with
That's
those
where I got
violations.
confused.
So
Thank you.
it's just those two.
Okay, Mr. Rock or Mr. Nexi, do you have any questions for Officer Gasson?
Yes, thank you. Officer Gasson, as part of your responsibilities and duties, do you oftentimes photograph violations when you observe them?
Sometimes, yes.
What about Mrs. Anexi's case on this particular property? Did you photograph all the violations that you observed on December 22nd?
I don't believe so.
Which ones didn't you?
I don't know. I'd have to look at the date of the photographs because they have the date on the bottom of them.
Well, did Ms. Anexi tell you that she paid $3,000 to have the pepper trees removed and treated?
She may have, yes.
Are you an arborist?
No.
Okay, so you don't know which trees that remained that you said that were over 4 feet were pepper trees or cherry laurels, do you?
Well, yes, because I remember specifically the one on what would be the northeast corner of her property was one of them I specifically did take a picture of before it was cut down, and it was a Brazilian pepper tree. So,
All right, sir. Let me ask you this. Did you ever ascertain whether or not Ms. Anexi ever had a site plan submitted that would require the Brazilian pepper trees to be removed and not replanted?
no, I didn't.
Okay. So the statute that you've cited her with is in fact a citation for a maintenance of Brazilian pepper trees after the site plan has been approved and they're supposed to be certified that they're all removed.
It's irrelevant. We're not discussing 13303. We're discussing 8-40 and 8-52. 13303 I'm not bringing before this board.
Now, do you customarily cite owners for property that's dumped on their property by somebody else?
That seems to be what occurs, yes.
Okay. Do you know whether or not Ms. Annexi has maintained her property and cleaned up other people's dumped junk on her properties?
I have no idea.
In fact, you took photographs on January 10th, did you not, including wood, including tires, and other property that was never really stored by the tenant or Ms. Annexi, correct?
I have no idea who put it there.
Did you know whether they've been cleaned up or not?
On January 10th?
Yes, sir.
It was still there on January 10th. took
I
photographs
understand,
of it.
but do you know that this property has been cleaned up even though it was not Ms. Annexi's property?
As of March 5th, it was correct.
Do you know whether or not Ms. Annexi has property maintenance people that remove property on occasion when it's dumped?
I have no idea.
Is not this property adjacent to an alleyway in the backyard, which makes it ripe for dumping?
That would be your opinion.
Well, what is your opinion?
Do you actually want me to answer my opinion?
Well, I guess you don't have an opinion.
Well, I can certainly provide you one, but are you willing to really accept my opinion?
No, I'm not saying that your opinion is accurate. I'm just saying, do you know whether or not people dump from the alleyways on people's backyards?
Sure, it happens everywhere.
Did you know that the fence that was put up that allegedly you cited as being unlawful was the neighbor's fence or not?
It's irrelevant. We're not discussing the fence. I'm not bringing that case before the board. That one's not here. 840 and 8-52 are what we're discussing, sir.
The furniture that you've described being talked about, is it still there today?
I do not know because I didn't look at it today.
Okay. But you certified that it was in compliance on March 5th.
That is correct.
And even if that furniture is there, you think that because, was it on the porch or because it was in the backyard that it was somehow junk?
It's kind of half and half. It's half on the porch, half in the backyard. I think in one of the pictures you can see it kind of hanging off the porch. But, sir, with all due respect, that's a chair. That was one of a multitude of issues. We can take the chair off the table if you'd like, and we don't have to even deal with it. Let's deal with the pile of concrete, the tires, the pile of wood, all the stuff inside the fenced-in area, and we'll not discuss the furniture.
All right, let's take a look at the rocks that you've taken a picture of.
Okay.
I think you took the picture on (2/7/18).
Okay.
You see a bunch of rocks out by a tree outside the
I see a bunch of broken concrete pieces, correct?
Okay. Do you know whether that stuff happens to be junk that's been dumped?
No, sir, I don't. It appears to be debris under the definition of the ordinance.
What about the you go back 2 pictures and you see some tires that appear to be there.
Yes, sir.
Do you know whether that's been dumped?
It appears to be debris under the definition of 8-52.
Okay. So, in answering my question, you really don't know whether it's been dumped.
Doesn't matter. Well, never mind.
Do you know that the property owner is obligated to clean up dumped property from a passerby?
Yes.
And if you had seen these violations that occurred that you took pictures of in February, you took pictures of some violations, correct?
Yes, sir.
Had you observed those in December, would you have taken a picture of those?
Well,
yes or no?
Actually, yes, I did take a picture of it. If you look at the photographs from December 22nd, the Brazilian pepper trees are blocking the debris. So
No,
yes,
I'm
I
not
did take a
talking-
picture, but
sir,
you can't see them.
I didn't ask you about the Brazilian pepper tree.
Okay.
I asked you about the pile of wood.
Okay, so yes, I took a picture of it. You just can't see it because the trees are in the way. And as I stated earlier, when people clean up their property, those things become apparent, and then I will take additional photographs.
Would you please tell me where the pile of wood is on any of the pictures that you took on December 22nd, 2017?
Certainly. It would be back behind a little bit to the south and to the west where the white mercury's backed in. But you can't see it because the white mercury and the trees are blocking your view. But that's where it was.
Is it your position that you do not enter personal property, take pictures?
Unless I'm invited. All these were taken from the alleyway.
So your job, as you described it, is to take photographs of violations that you observe, correct?
One of them, yes. But I don't necessarily have to take photographs, but I choose to. They're a bit
Well,
more demonstrative.
When you gave Mrs. Annexi a citation on 12/22, did you not list what you observed and you photographed on January 10th, 2018?
Rephrase your question?
All right. You gave Mrs. Annexi a citation on 12/22/17.
Correct.
You took photographs. You gave her a list of the violations, correct?
Correct.
And other violations that you noted were taken after or observed after January 10th, 2018, correct?
Yes. Because I couldn't see them before.
After you observed them in January, did you ever bother to amend your information or your code violation to include the other items or just take pictures?
I didn't need to.
You didn't answer the question.
No. I didn't need to.
I'm going to ask the court reporter to strike the answer as not being responsive to the question.
There's no court reporter.
I understand, but this is on YouTube for the record.
Okay.
Officer
Mhm.
Gasson, did you ever ascertain whether the vehicle was operable or duly licensed that you took the photograph of?
It's irrelevant. We're not discussing the vehicle. It was moved. It was in compliance. It's gone.
So you're not asking that any sort of a fine be imposed for the
Now, as I
storage?
stated earlier, sir, and I'll say it one more time, 8-40, 8-52. Every other violation, we're not here to discuss. It's not before this board for consideration.
Well, I guess because you've so gratuitously eliminated them, which ones are we here for?
Again, 8-40 and 8-52.
Specifically, what are the facts? Which
Want me to read you the definition of debris under our ordinance?
No, I'm asking for you to tell me what debris that you observed on December 22nd.
Well, originally, 852 also encompasses maintaining your lot for overgrowth. So as I stated, and just to let the record reflect, a citation was never issued in this. So Mr. Rock continues to refer to that. That's not what occurs. We didn't issue a citation. A notice of violation was issued. It's not the same thing. So once that error is cleared up, I inspected the neighboring property and discovered numerous violations on this property. We talked about the trees. We talked about the car. And then trash and debris on property needs to be cleaned and mowed. Fences in poor condition. So just stopping at that sentence. Trash and debris on property. So I covered debris, which is under the definition under 852. Okay. So there's debris on the property. Once the trees were cleaned up, I was able to specifically see more of that, and that was noted. But because I covered it once, the ordinance doesn't say one specific thing has to be removed. It's all of them. And that's how that ordinance works. So it just so happened that more was discovered as the cleanup progressed.
That's your suspicion or belief at the time?
No, that's the facts based on the photographs that I've presented to this board.
No. It doesn't reflect that. It reflects that you have new violations. When you say that you've notified her of violations, haven't you only given her a notice of repeat violator?
Correct, for 840 and 852.
Okay.
And included with those notices are the definition and the ordinances themselves.
Sir,
Including what the definition
I
of
understand
debris
that,
is.
but I see a lot of photographs that you're admitting right now are really not relevant to this charge, correct?
No,
Okay.
that would be your opinion.
You've included a photograph dated 1/10/18 of some apparent trees that I guess it's probably 1, 2, 3, 4, 6 photograph dated 1/10/18. Are those the trees that you think that you're not sure what type they are?
Mr. Rock, I don't know why we continue to talk about trees. It's not before this board for consideration. So I would object to the relevance of it.
I thought I was asking the questions.
Well, I'm also have to be the prosecutor, so I'm objecting to the relevance of that question. Which
Are you going to be the judge and make a ruling on your own motion?
No, I'm asking the board to rule on it.
So, Madam Chair, there's been an objection to the question raised about the trees on the property. The objection is not relevant to the case, and so you need to determine whether or not the question being asked by Mr. Rock relative to the trees is relevant. If it is relevant, then you need to overrule the objection. Otherwise, you need to sustain the objection. He can continue on with his line of questions.
The trees don't have anything to do with what's on before us today, so I don't know why you need to keep questioning.
So the objection has been sustained, Mr.
Thank you.
Rock. Thanks.
Did you notify Ms. Annexi or Annexi Group LLC titled Notice of Repeat Violator or Notice of Repeat Violation?
I'd have to look at the notice. I don't know if it has an S at the end of it or not, but she's a repeat violator. The property owner is.
For the same statute or other code violations?
For 8-40 and 8-52.
Did Ms. Annexi ever tell you that she had the property cleaned up on many occasions, including property that was dumped by other people?
Mr. Rock, I testified that I've had numerous visits with Miss Annexi. She's called numerous times. So yes, she's notified us the property's been cleaned up. She stated that she believes it's been dumped on. Unfortunately, the property owner's responsible for that. I can't help that.
Just questions. Do you have any more questions?
Did,
Mr.
yes, did Ms. Annexi ever present you with an invoice from the person who removed the Brazilian pepper branches and had the property sprayed?
Sir, I'm going to object to that question as well because it's irrelevant. Madam Chairman, once again, the trees are not before this board and I would object to that.
Sustain.
That's all the questions I have of this witness at this time.
Okay, we need to find out whether or not Mr. Gasson has any other witnesses first. You have any other witnesses?
I do not.
Okay. He can present his case.
Present your case, Mr. Rock.
Thank you. I call Mr. Chris Conrad, please.
Sir, were you sworn in earlier today? I think you were.
Yes.
Okay.
Would you state your name, please?
Christopher Conrad.
What is your profession, trade, or occupation?
You're going to have to talk into the mic because we won't pick it up. Thank you.
What is your profession, trade, or occupation?
Craftsman and carpenter.
Do you maintain Mrs. Annexi's properties on occasion when she requests that you do?
Yes, sir.
Did you have occasion to remove debris from Mrs. Annexi's property back in December of 2017?
As soon as I was notified, within 24 hours, the debris was removed.
Did you subsequently find out in 2018 that some additional property had been dumped onto Mrs. Annexi's property?
I did.
And did you remove it?
Yes.
I'm going to show you some photographs. Taken by Officer Gasson, and I'm not sure of the numbers, but I believe they're the last two taken on 2/7/18.
Yes, sir. I'm familiar with these photographs. We were informed by one of the staff from the code compliance office. And that same day, those broken stones or bricks were removed.
Had that debris been dumped there since January of 2018?
I believe so because I wasn't aware of the condition. And as you can see, the photograph has a cover now on the gate and all the debris inside and the fencing was repaired.
So that the nuisance allegations or photographs of 2/7/18 have nothing to do with the original charge that took place back in December of 2017, did it?
No.
The debris that's shown on 2/7/18, was that debris there in December of 2017?
We stacked that there. It wasn't there prior. We placed that there as we cleaned up the yard. It was old fence posts from the fence that we removed. And we're in the process of removing the balance of that.
So you were in the cleanup process anyway?
Yes.
You weren't storing it there?
No. No, if you can see in the photograph, most of that's all the old fence wood. And we removed the fence on the borderline.
Have you had occasion to see some of the furniture being stored on the back porch at the house?
Yes.
Some of the older furniture?
There are two older chairs that are in question. One that was hanging halfway off the porch had a broken leg. That was repaired.
Has any of that property been abandoned?
Yes. By previous tenants.
No. Has the tenant there or Ms. Annexi dumped property there to abandon it? Or is it presently being used by the tenant?
It's presently being used by the tenant. By the new tenant.
Has Ms. Annexi asked you on occasion to clean up properties, including this property on Lemon?
Yes, sir.
And your response is to drag your feet or immediately go and repair it?
No, it's immediate. It's within the same day, within 24 hours.
Do you have on occasion property being dumped there by anybody who wants to dump junk in her backyard?
On 3 occasions since October, this particular property has been dumped on 3 times.
And has Ms. Annexi requested that you clean it up each and every time?
As soon as we found out about it, yes, absolutely. Immediately we clean it up.
Have you had any conversations with code enforcement about inspecting the property?
Ms. Annexi handles all that. I don't do any of that.
That's all I have.
I would like to, be notified if there are any violations and they're unable to get a hold of Ms. Annexi. I'm glad to take care of any infractions or violations on any of the properties immediately.
Okay, does the board have any questions for Mr. Rock?
Actually, Mr. Conrad, isn't it?
Conrad? Okay. Any questions? Yes.
Mr. Conrad,
Yes, sir.
you state you went out on December, what date did you go out and clean the property up the first time?
I'm not sure the exact date because as soon as Ms. Annexi is notified of these things, she tells me, and we go out immediately and take care of whatever it is that needs to be addressed.
Do you bill her? You charge her?
Accordingly, probably, yes.
Do you do any invoicing, record keeping?
No, my eyesight, I'm having a problem with my eyesight.
All right, so you don't do any paperwork for taxes or anything like that, right?
No, I'm doing
Okay.
mostly for.
Okay, so you have no idea what date you went out and cleaned the property up, but you did it immediately, correct?
Sorry?
You have no idea what date you went out and cleaned the property up.
I took photographs after I was done to show that it was cleaned up, sent to her, so that she could see everything that was done.
What date was that?
Remember getting a call from a Miss Vicky, and I think that was on the 5th. And by the end of the day, it was one of the last issues with the broken bricks.
So the 5th of what month?
That would be the 5th of February.
5th of February. So you went out and cleaned it up on the 5th of February. Is that what you're saying?
Not sure of the date, but I believe that was it. Yes, that was a while back with those bricks and that fence.
Okay. On the 5th of February, what'd you clean up specifically from the property?
That would be the wood. There was some debris. Oh, I'm sorry, excuse me. But there was some wood and some debris.
What kind of debris?
Some extra pieces of fence. The stones on the corner around the fence. I cleaned all that area around that whole structure and resecured it.
Okay. So you never went out in December or January, what you're saying?
Don't know that I was even notified of any issues on that property.
Okay. Did you go out more than once?
It goes back a while. I've been working for Mr. Nexie for quite some time, almost a year now, solid year now. So just helping her, maintain some of the property.
Did you go out more than one time to clean up anything?
On Lemon Street, I've been out there on multiple occasions. I've done quite a few repairs.
After January 5th? After the first time you went out there, you've been out multiple times?
Yeah.
What was the reason for that?
Oh, the issue with the furniture. Wanted to clean that up, make sure that was.
What did you do with the furniture?
The furniture was put back into what was a screened-in porch, I assume, before the hurricane hit. Screening got all torn up. I took down the torn screen and put the furniture back up, set everything up, cleaned it up nice, and repaired a leg on the chair.
Okay, so it was out in the yard?
The one leg
Ish?
was hanging out
Okay.
off the patio.
So did you pick up any broken pieces of concrete?
Yes.
Okay.
A lot.
Did you pick up any tires?
I believe there was one.
Okay.
One or two.
Were they, was there grass around them or anything like that? Do you
There's
recall?
There were some vines in the back by the neighbor's property.
Into the tires?
Yeah, they probably.
Okay.
No, when I wheeled the tires out, the tires came. Just I pushed them out.
Okay. I have no
didn't
further
too
questions.
Much hard time getting the tires out.
Yeah. So now is the opportunity for Mr. Rock, if he has any redirect, he gets to ask that witness any more questions before he calls his next witness. Any redirect, Mr. Rock?
Yeah. Did you get requests from Ms. Annexi several times to go to the property after January because new dumps, new debris had been located that were not even in the pictures in December?
Yes, there's a series of metal roofing debris that I discovered came from a neighboring property. And after speaking with that neighbor, he appreciated that we removed that, and we came with truck and trailer and removed all that metal debris that we could find.
Is that some of the debris on 11018
Yep.
that
Yep, the roofing material, yes.
that the neighbor had put there
Yes.
after December 22nd?
Yep.
And these pictures of the tires, are those the tires that you removed
Yes.
that had been placed on the property after that date? Or, excuse me, after December
I can't
22nd?
I can't confirm when they were placed there. I didn't even see them there, so I couldn't tell you until I was notified of them and removed them.
Now, this photograph on 2718 shows part of the screen that you just talked about as having been coming off from a hurricane.
Yes.
And this chair, which has the broken leg, is that entirely in the porch?
No, it's hanging out just a little bit there.
Because
It was
it's
on
leaning on the
edge.
post?
Yes, I guess it got blown over toward the post and the leg broke. I don't know.
But it's not junk.
No, she uses it now. She has it set up with a nice little patio now.
I don't have any other questions of this witness.
You may call your next witness.
Call Kristen Farron.
And you were sworn in, ma'am?
Would you state your name, please?
Kristen Barron,
Where do you live?
439 East Lemon Street, Unit B, Tarpon Springs, 34689.
Is that close to the property in question?
That is the property.
And to your knowledge, has that furniture been repaired?
Well, we discussed it. See, what I had done is I had it all out, like, you know, it's an Italian thing. You don't really much. I always just like find a use for things.
We can't hear you. Speak into the microphone.
Okay. So no, I just put everything else up nicely out there, and we're actually getting rid of it because I have new furniture coming in.
Did you use the property?
Yeah, I just said that. Did you not hear me?
Wasn't quite finished with my question. Were you using this furniture in February of 2018?
Yes.
And one of them had a broken leg, and it's been repaired.
Yeah, I mean, who cares? It's leaning on a post.
This is a photograph of some debris outside the fence or outside the shed. Is that bunch of rocks, stuff there, been put there since December of 2017?
Has it been? I wasn't there before December of 2017, so.
But there is no rocks there presently, correct?
No.
Were you present when the Chris gentleman who removed a lot of the fence posts and a lot of the debris?
I never even saw that stuff, so yeah, it's obviously been removed since.
How long have you been at the property?
Since February 1st. So, no, and I haven't seen any of that. That's why when she asked me about a car, I was like, I don't even know what you're talking about. None of that stuff's even there anymore.
That's all I have.
Okay.
Do you have any questions?
Real quick, you stated you moved in February 1st?
Yeah.
Okay. You live in the front or the back?
The back.
Do you go in the backyard?
Yeah, actually.
You do?
outside.
You've never seen any pieces of concrete in the backyard after you moved in February?
I haven't seen pieces of, there's a little like fire pit thing.
Well,
but
let
that's
me
it.
refer to the
It's not what was
photographs that
shown in
Mr.
the
Rock
picture.
has. If you look at the ones dated February 7th, 2018, they're going to be towards the end of the stack. There's a tree, a wrought iron gate, and there's a number of pieces of concrete. That's on February 7th. So did you ever see that there?
That they're gone. She
Okay.
had two people.
I understand that. We don't have a problem with them being gone. Did you see them there?
Yeah, I saw people removing things from there, to be honest with you. I was
Who were the people removing things?
Maria had hired people to come and clean up the yard and get rid of all that stuff. So,
How many times did you see the gentleman that was testifying before you, Mr. McCormick, out there?
oh, he comes over a lot.
Okay. Do other people come out there too?
I'm sorry.
Do other people come out there and clean things up?
We've had the plumber come out. I mean, whatever issue there is, Maria always calls
Okay.
somebody.
I have no further questions.
Do you have any redirect?
Okay, so next witness.
Next witness.
All right, you need to face the clerk right over here, sir.
Oh, thank you. Do you swear to testimony about to give us the whole truth and nothing but the truth, sir? Thank you.
Mr. Morphesis, I'm going to give you some black and whites, and we'll introduce the copies of the color present to the city for evidence.
Morphesis. Can Mr. Rock, can you spell his name?
G-E-R.
Yeah, full name is first name is Gerasimo. That's Greek version of Jerusalem. And last name is Morphesis, Morfesis, Morphesis.
I'm going to hand you these copies, and I'm going to introduce do I give them to the clerk, or do I give them to the prosecutor?
Well, Dan, what you need to do is to give them to Mr. Gasson, and then ultimately, if there is no objection, they'll be provided to the clerk.
there's a number of pictures in here that are completely irrelevant to this case because they have absolutely nothing to do with the property address. The first picture, which depicts a wooden fence and an iron gate, that is of the property. I have no idea, exhibit number 3, which property it is because I've never been on the property, so it could be that property. If
Okay, why don't we do this? Since they're going to be...
they're individually numbered, so I can...
Okay, well, let's do this. Why don't you just go ahead and present Mr. Rock, and then present them one at a time, and then you get more information, and it may make it relevant.
Thank you. Mr. Morfesis, I'm going to show you what's been labeled Exhibit 2 for identification. Have you gone to this property and taken these pictures?
Yes, I have.
Just leave it. Is this a property that we are here today about?
Yes, that's the enclosure in the back of the property in question on Lemon Street.
Okay. And that's the tree where the bricks were supposedly dumped?
Yes, that is about 7 feet south of the alley and where the shed is at, and that was the area that previously had the various debris of rocks and concrete block.
All right. Photograph, I'd like to introduce it.
Sorry, I'm just going to handle this because
Go ahead.
okay. Any objection to exhibit number 2, which is the one he's referring to?
Do we have a date? I would object to it. I mean, just simply by, I'd just like to have the date on it or know what date it was taken.
Yes, that photo was taken yesterday.
Yesterday. Any objection?
No, no objection.
So
all these photographs were taken the same date?
The ones I think that Attorney Inspector Gasson is, the other ones that are of the alley and the properties around that he was questioning, those were taken April 15th.
Well, let's talk about exhibit number 3. Is this the backyard in question?
Yes, that is the west area of the formerly screened-in porch where the mystery piece of furniture that Inspector Gasson didn't like was placed.
Photograph 4?
Yes.
Is that recently?
Yes, that was the photo yesterday showing the furniture that was in his original picture that he apparently described as debris and junk.
And is it, as best you could tell, is it presently being used?
Yes, it's presently being used. It's set in a format, 4 chairs circular around the table there, and it was obviously currently in use. The opposite chair, the one that has the back, the sister chair is on the opposite side of it from the table.
What is?
Exhibit 5?
Yes, sir.
Exhibit 5 is 428 Tarpon Avenue, part of the statute as the city uses has to do with how other properties are affected by the condition of a property. I was asked to look at the various properties in the area to see if the condition of Lemon Street was any different than the other properties across that existed there. This is a photo at 428 Tarpon Avenue with a bent and broken fence, which has its numeration. Also has a bunch of debris stacked up for apparently for dumping purposes by a trailer that's sitting in the backyard at that time.
I
was
would
on the
object to that
15th of
photograph.
April.
It has no relevance to this case. We're talking about 439. I'll make this easy. The rest of the exhibits 5 through 10 aren't relevant to this property, and I would object to all 5 through 10. And I have no objection to exhibit number 1, which is some invoice talking about cutting down pepper trees. I have no problem. I've already made my case that we're not talking about pepper trees, so I have no objection to that.
Sustained.
All right, I'm going to go ahead and make a proffer of those exhibits. Now, let's drop down to photograph number 8. What is photographs number 8 and 9?
Photographs number 8 is the front of 460 Lemon Street, which is right across the street from the property at issue. Exhibit 9 is 4 vehicles that are in the condition of having no plates, 2 without cars, and 2 that are half torn apart, looking like they're being rebuilt.
Were they there back in April?
Yes, they were.
Are they there now?
They've been there for over 6 months. I regularly drive down that street.
I'd like to introduce those 8 and 9.
So let me just make sure that I've got this clear so far. So we're trying to keep track of the record, Mr. Rock. So number one, there is no objection to number one coming into evidence. Number two, there was no objection coming into evidence. Number 3 and 4 you discussed, but you did not offer them yet. Number 5 was found to be not relevant, and so forth. The objection was sustained. Now you're offering 8 and 9, is that correct?
For the record, I would go ahead and offer at this time photographs number 3 and 4.
Any objection to 3 and 4?
No.
Okay. So, Madam Chair, we'd receive 1, 2, 3, and 4 into evidence so far.
Okay, Bob, if you receive those into evidence, please.
Just those.
Okay, 5 was a no. And now you're offering 8 and 9?
No, I actually he objected to.
I objected to 5
6,
through
and
10.
7.
He objected to 5 through 10 as being not relevant. He's proffering 8 and 9 at this point. Do you want to proffer 6, 7, and 10 as well?
Yes, sir.
Okay. And did you want to do that now?
Yes, sir. I assume that his objection to photographs that I hadn't even attempted to introduce is, if I'm not mistaken, is sustained. So 6 through 8 is.
Well, first of all, I don't agree with your characterization. You handed him all of the photographs in the beginning. He's had the opportunity to review them, and he's objected to them based upon the fact that you've already handed them to him. So I don't agree with your characterization. But, so, Madam Chair, I believe what I heard is that he made an objection for 5 through 10 because these are properties not associated with this particular one. In other words, it's not 439 East Lemon Street. And you sustained that objection. So Mr. Rock, under the law, has the ability to present these exhibits 5 through 10. He's what we call proffering them, so that if he appeals this decision and the circuit court that he appeals to determines that the board has made a mistake in not allowing these pieces of evidence in, that he could use that in part of his appeal. So that's what he's doing now. So, and I guess these exhibits are coming down now that you're seeing. So you want to go ahead and proffer then 6, 7, and 10. You've already proffered 8 and 9.
Yes, sir. I would like my witness to testify as
Absolutely.
to particularly number 10.
Okay.
Let's go back, if I may, back to 6, 7, 6 and 7, and have him testify why he photographed them, even though I understand they're not being admitted into this hearing.
For the
I'm going to object to relevance.
Okay, so
This is the prop.
yeah, you can proffer the evidence, and that's what the process for you to do, Mr. Rock, is to proffer them. You're proffering 5, 6, 7, 8, 9, and 10.
Correct.
And he's objecting to testimony about those. So
Under the Powell versus City of Sarasota case, we have the burden to prove the affirmative defense of selective enforcement. If you're not going to permit any testimony by the witness, I understand I've done my job.
okay, well, there's been no affirmative defense raised in this case so far. So
Specifically, why I am introducing these photographs.
okay, so the objection now, Chairman, is Madam Chair, is to the testimony that he is going to have his witness testify to as to exhibits 6, 7, 8, 9, and 10. My suggestion to you and my advice to you is that you allow that testimony to move forward, hear the testimony, and you make determination in your own mind whatever probative value that it has, and then we can avoid that being some type of error on the part of the board. So just give it whatever weight that you feel is appropriate based upon, I assume Mr. Rock is going to make an argument in his summary that the city is selectively enforcing the code against his client. So my advice to you, Madam Chair, is to overrule Mr. Gasson's objection, allow the testimony and give it any weight that you believe that is necessary to give it to it.
Okay, I'll overrule it and let him finish.
Let's go back to, thank you, Madam Chairman, go back to number 6 and 7 and what do they appear to represent. Why did you take the photograph?
I took the photographs. The Officer Gasson had described his review of the issues with Lemon Street from the alley because all the items that he described are not visible from the alley. So obviously, he had to go through the alley, either from the east or the west side, to get to the property which is in the middle of the street. So therefore, in reflecting the statute, whether or not the other properties were in similar condition, and if Lemon Street was such a difference in condition that it should be fined for creating loss of value to the properties nearby. So doing that, again, this is 428, number 6, Exhibit 6 is again 428. It shows an unkept yard, has the items that are kept, apparently construction debris on trailer on the right side of the photo. The fence, again, you still see where the number was 428. And in fact, that tree is overgrown over the city alley, which does have some confusion because the alley is physically at points only 10 feet, even though it's 17 feet across, according to the records of Pinellas County appraiser.
Was this property any worse, the Green Street, Lemon Street property that we're talking about, any worse in appearance than any other property on Lemon Street?
No, the Lemon Street alley is a unkept alley by the city. It has large divots of asphalt. You cannot drive across it quickly because it hasn't been maintained for a number of years. It may have to do with it being perhaps the original street in Tarpon, the Vincennes Funeral Home, where the original county commissioners, and so that might explain why the alley doesn't conform to the actual Pinellas records. But pretty much every property is either overgrown into the alley of the city or has debris in the back or has unkept fences. There's no one who would argue that any of those properties, even the Vincennes Funeral Home, was a Class A type kept property at any which way, shape, or form.
Now, 8 and 9, I'm going to, since the charge of maintaining a motor vehicle has been withdrawn by the city, as far as this hearing is concerned, 8 and 9, we don't really have to raise the selective enforcement defense. Let's go to photograph number 10.
Yes. That is the area behind 460 where the cars that I previously described in exhibit number 9 have been kept for a large amount of time on Lemon Street. Behind there is an area that is not properly draining. There's a large tree, and next to the tree in the photo, there are 2 boats that are not only unregistered and licensed, but don't even have a tag number at all, and that is at 460 Lemon Street.
Do they appear to be a nuisance to you?
They're certainly a bigger nuisance than what was described at the current property at 439 Lemon Street.
That's all I have of this witness.
Board have any questions? Yes.
Do you have photos that represent these other properties over a period of time so we can have a perspective on that? The officer presented, a number of months, and I'm only seeing 1 month of somebody else's stuff.
In terms of 8, 9, and 10, even though it's across the street from Lemon, it's a road that I regularly take in Tarpon Springs, so there are no photos because I wasn't asked to be a part of this case at that time, so I wasn't asked to take the photos. I can describe specifically about 460 with the vehicles in the front. I did not observe the boat in the back of 460 at any time prior. I did not go through the alley. It's like I said, a broken down alley. You have to go very slow. There's no reason to go down that alley unless you choose to go down the alley. So I can only testify into the 2 vehicles that are dilapidated, unregistered, and 2 pickup trucks that are half broken that have been sitting there on Lemon Street for many, many months.
And following that up with, do you have personal knowledge that these other properties have not been cited? How would you know if that it's selective?
I reviewed the county, the city has a record and a database, although a few of those properties seem to have had some minor issues over the years. There's nothing currently, so if I understood the testimony from Officer Gasson, he happened to be visiting another property in the back, that's how he noticed these issues that you couldn't see from the street. I would only guess that I can't speak for his mindset as to why he didn't cite the rest of the properties on the street when he was driving in and around the alley.
Any other questions, ma'am?
Were we supposed to have these other photos to look at?
No, he's proffered them, and they're not going to be received into evidence because they've been sustained.
Okay, I didn't know what proffered.
Yeah, but he basically is making them, we're going to label them, but you won't be able to see them as evidence. And he's putting them in the record so that the appellate level court, if he appeals the decision, will have that information available to determine whether or not that's a mistake that was made by the board or not in receiving it. So just he's perfecting the record is what the lawyers call it. Okay.
I have a question. Are you a photographer?
I've taken video and television production work, so I went to college for that. I've done probably in Chicago, I did probably about 50 or 60 television programs. I've done some minor freelance work, but if you're asking me, have I turned it into a career? No.
And are you a neighbor of Mr. Nexie's properties?
Well, she has various properties, but no, I'm not an immediate neighbor of any of her properties.
I have questions. So, Mr. Morpheus, I appreciate you submitting pictures of the property being in compliance a month after it was in compliance. Quick question about exhibit number 9, since I've already objected to these, but you were allowed to testify to them. Do you know what kind of property that is in number 9? What it's zoned?
I'm sorry, Mr. Gaston, you remember the Florida Bar?
I'm sorry?
Are you a member of the Florida Bar?
You don't get to ask questions. He's cross-examining you, okay? So you either need to answer the question or tell us why you're not going to answer the question.
Okay. I'm sure Mr. Gasson will think otherwise, but I've done much things for law enforcement along the years, along the way. And I don't believe Mr. Gasson, he has the capacity based on your rules to prefer evidence. I don't know that he can cross-examine, and I'm not going to submit. He can ask the board to ask the questions. The board can ask perhaps, but I believe he's committing a felony because the rules
Okay, all right,
don't
we're
allow
going to stop
that.
you right there. So the board is allowing you to testify.
Right.
You have testified.
Right.
You're subject to cross-examination by
I'm a
the
member of the
city.
bar.
And he does not have to be a lawyer. Just like Ms. Anexi didn't have to be represented by a lawyer, the city doesn't have to be represented by a lawyer. So his question.
Okay, I'll answer the question. That's
Okay,
fine. You
thank
made
you.
your point. Thank you. Go ahead.
So, Mr. Morpheus, do you know,
Morpheus, please.
sorry, Morpheus, do you know how that property is zoned in exhibit number 9?
It appears to be a retail space with some other commercial use on it. I haven't looked at the zoning, if you're asking.
So
me.
commercial.
Yes.
So you're arguing that because there's cars parked out front, that it's a violation? That what your statement was?
I've owned over 300 pieces of real estate, both commercial and
Simple
residential,
question,
so the
sir.
answer is from my knowledge and experience, it would appear to be a violation.
Okay. How familiar are you with city code 40.00, which is what I'm assuming you're alleging is that violation?
I'm sorry, which one?
40.00.
40.00, read it to me, or explain it
Really
to me.
quick, no abandoned vehicle shall be parked or stored on any residentially owned property.
Oh, is that the
So it's kind of a
city?
moot
Is
point.
that the city or the international code that you're referring to?
City code.
Okay, but the city refers to the international code, so you're saying it's part of the international code?
No, we're not looking at IPMC. We're looking at
but
City of Tarpon Springs
Right,
ordinance
but the city's
40.00.
ordinance specifically says that you will follow the international code. So you're saying there's an additional ordinance that I'm not aware of? That's all I'm asking.
You need to stop being a lawyer. You're a witness. Just answer the questions.
I'm not aware of that ordinance, no, sir.
Okay. So did you get your question answered?
Loosely.
Okay.
Good enough.
Any other
I'm
questions?
done with any cross-examination of this witness because I can see that it's going to be an extended process and probably not get us anywhere. So.
Yeah, before the cases, and I mean, do you have a question relative to this witness?
No, not this witness.
Okay.
Well, things he said.
Okay, so, you have any other witnesses then, Mr. Rugg? Okay.
Want these Crawford ones?
Yeah, I need to mark those. Okay.
State your name, please.
Oh, Mary Annexie.
And Ms. Annexie, what does Exhibit 1 appear to be?
The bill that I had for 439 East Lemon Street, when Mr. Gasson told me about the problem there, I called all the way up tree service. They charged me $3,000 to trim it. And the reason I bought the house when my mother was alive then is I liked the landscaping. I thought it was very pretty. Anyway, we did tremendous work. I didn't. The
Mr. Annexie, I
tree
think
service
you
did.
answered the question.
Yeah.
The invoice was for the removal of the pepper tree.
Yes, all the debris, the tree landscape. Yes.
Did Inspector Gasson come out to the property in early of January 2018 because you requested the property be re-inspected?
I can't remember. Oh my God, did he? Did you have the paper? Maybe he did.
Well, according to their paper, you had called the city and requested
Yeah,
a re-inspection
right.
in early January.
Yes. This was done 12/10. Yeah, 30. Yes.
Had there been additional debris put on the property by dumpers that was cleaned up by your maintenance man after January that wasn't even in existence in December?
Right. The people go down the back driveway of this Lemon Street and they throw tires, they throw metal, they throw bricks, stones, any kind of junk. Because I had a gate, a brand new gate. It cost over $1,000 when we purchased the house in the back. And some driver, not my tenants, they're nice people. They didn't even have a car. Bashed the gate, so we had to remove the gate. And it's not worth it. I'm not going to spend more money for somebody to hit it again. And they just go down and use it like a dump yard.
Is it actually, do you keep the property clean as
Yes.
soon as you are notified of any condition?
Immediately.
Has Officer Gasson ever notified you of any condition other than the citation? Have you ever gotten a call from Officer Gasson saying you
No.
got a problem?
No, he'll cite me, to my knowledge, I believe.
Have you ever been given any amended citations other than, or notice of code violations, other than what you received back in
Not to my knowledge.
December
Right.
of 2017, related to this charge, to this property?
No.
You have seen other photographs, even as recently as February, where other people have dumped property and you've
Yes.
had it cleaned up.
Yes, absolutely. I don't know what to do with the traffic back there. I don't know what to do. I have to check it like every other day, driving the back. And it's a bad driveway. It's very bad on your tires.
I have nothing.
Yeah. I'm the new dump section in Tarpon. If you need
Board
it.
have any questions from Ms. Annexie?
Briefly, you and I numerous times met out there, correct?
Yes,
Okay. And I pointed out the debris inside the fenced-in area to you, correct?
yes. The wood you're talking about that somebody,
I'm talking January 10th, 2018. I took a picture into that little mocked-up fenced area and all the debris that was in it. Pointed that out to you, correct?
yes, that's all corrected.
I was
No,
just
those
asking
aren't
if I
mine.
pointed it out to you.
Right.
Okay, so it was there then. Does it look like somebody went through just in your opinion, do you think somebody went through the effort of throwing it over the fence into that little area?
There's an open driveway now because we removed the fences.
Is that not all fenced in though with a gate?
No, it's just a little bit on the right. You can actually put a car in it because sometimes we need a truck, if they like the tree people and those
All right,
people.
I think we're not talking about the same area.
The back of Lemon Street you're talking about.
I photographed February 7th,
Yes.
2018. The wrought iron gate that's on the little wooden fenced in area
Oh, the shed. I call it a shed.
without a roof.
Yeah, that's
Okay.
just a storage. It was like that when I bought the
And
place.
we
All
pointed
that
out in
debris
front
is
of it,
gone.
you see the broken cement there, right?
It's all gone.
Okay.
We didn't do that.
Back in February, it was
Mhm.
there, correct? It's a fair
Yes.
statement? Okay.
It's all gone.
All gone. Who'd you have clean it up?
Chris does everything. Chris is very good. He does plumbing.
How many times did you have Chris come back out?
Many times we did it. About
Okay.
maybe 4 times.
Okay. You recall the 2017 case or 15 case, the same property where you had to clean it up? Well, she's a repeat violator. That case established her, but that's fine. I'll withdraw my question.
The same property?
I withdraw my question. No, I have nothing further.
Okay. Any other witnesses, Mr. Rock? Okay. So, Madam Chair, before you close that public hearing, you said that you had a question that you wanted to ask of Mr.
Yes.
Gasson? Okay. Now is your time before you close that public portion.
Even if junk has been dumped in the owner's property, isn't it the owner's responsibility to pick it up? clean it up?
Unfortunately, yes, it is.
You are allowed to go in the alleyway, correct?
Yes, as it was stated by, it's platted public right away.
And your photographs, or you're not questioning any debris that's in the alleyway, are you?
No,
Just on the property?
just one property. And, yeah, never mind, I'll cover it in my closing, but yeah, just the one
Okay.
property.
Okay, so now would be the time for
Yeah.
Mr. Gasson to summarize and Mr. Rock to summarize as to the violations only. Not compliance, not fines, anything like that.
Hold on.
Yes.
Just briefly, I started this case, I realized I objected to it. The only reason I'm discussing trees is because the trees were cleaned up, which allowed other things to be seen. Originally, in the very beginning, back in December, you can see in the photographs there was debris. Debris is unused material. There was metal laying there. There's a shopping cart. The car was a different point. And then even my pictures that were taken December 22nd, you can see items leaning up against the wooden fence near the wrought iron gate that even appear to be a piece of concrete, which is very similar to what shows up in the later photographs dated February 7th. Briefly touching on selective enforcement, we were all present for their neighbors who I opened a case on. As a matter of fact, I opened the case on based on Marion Exey's property, which was based on trees being dumped on the property to the east of her. That got cleaned up. It didn't come to code board. I then had the property to the north written up so they could get their trees and debris that were extending into the alleyway also cleaned up. Selective enforcement, nah. I realize there's some court cases there for that, but I think we've pretty well established, even considering this board just heard the neighboring property. So it's kind of interesting that I'm selectively enforcing. So that's covered. There's debris on the property. It's been cleaned up. It was in violation for 73 days. Her own cleanup guy's testimony puts it into, I believe, February was when he first got out there. I'm sorry, January 5th. I believe is what he testified to. So, and he's not even sure of the dates. Exhibit number 1 that was before the board regarding the trees being cut down, you can clearly tell the date that was written on it is different than the rest of the handwriting. I'm not a handwriting expert. I'll say that now, but it doesn't have to be a handwriting expert to see that the ink is different than the other rest of it. So the date's questionable on that, but I have no objection to that because I've taken trees off of it. So we're here to discuss debris. Marion Exey stated she's called her person out numerous times to clean up debris off the property. They proffered photographs, or they put their own photographs into evidence showing it's in compliance. I have no argument with that. I stated it was in compliance. It was out of compliance for 73 days. She had prior cases for other properties that she owned that put her in violation, including this property. So under the statute, under our ordinance, she's a repeat violator for 73 days. And that's basically sum and substance of this case, is a violation of 8-40 and a violation of 8-52. The umbrella of debris is large and covers numerous things. The fact that I see one thing, if things are done to the property that present other items of debris, they are still the violation. the violation still isn't fixed, you know? So just because we don't have to specify in the notice of violation, pick up 47 pieces of cement. It's debris as defined below to be cleaned up. So that's what was done. Unfortunately, as the cleanup occurred, more debris appeared. And that's the situation we're in. And it took 73 days for the property to finally get cleaned up. As I stated, in regards to all the other properties, they're more than welcome to call in code cases. I'll be more than happy to go out and investigate them. Primarily, as this board's heard numerous times, I'm reactive rather than proactive. The majority of my cases come from, and in this case, I wrote up neighboring properties because of the violations on her property. So, and that's all I have at this point.
Madam Chair, I need to correct my statement earlier. You know, this is a repeat violation, so this isn't separated into two motions like an initial violation. So I just want to make that clear before we hear the summary argument and closing for Mr. Rock, that your normal process is to determine whether the violation exists if it's a repeat, when the start date would be if it's a repeat, how long it went, what the dollar amount of the fine is. So I apologize. You know, it's not an initial violation. It's being alleged to be a repeat violation. So that's your one motion, the form that you use, and it's in your binder. So it's not two motions like an initial violation. So I just want to make that clear before we get to the argument being made by Mr. Rock.
I had a question about that. When it was set as the first violation, and then the second motion was made to establish a fine, how do we know what that fine was to figure the dollar amount for this time?
This does not have anything to do with the dollar amount of the prior fine. You need to determine, based upon the testimony and evidence that you've heard today, and take into consider the three things that are required by the statute, whether she's been cited before, the gravity of the violation, and what she's done to bring the property into compliance. Those are the three factors you use to determine under the state statute as to the value of the fine, $0 to $500 a day. That's your parameters. So with that in mind, we should let Mr. Rock finish his case.
If you would look at the, if you would look at the violation notice, it doesn't say notice of repeat violation. It says notice of repeat violator. Officer Gasson is trying to change his terminology somewhat. In fact, he said, well, she owns several properties, and a conviction on one or a finding of nuisance on one is a finding of nuisance on all. But essentially, that's not what the law says. It's limited to each piece of property. So it's a notice of repeat violation, to state that correctly. Secondly, there has been evidence, undisputed evidence from Chris and from Marion Exey that this property has had property dumped on it since the original violations that occurred on December 22nd. You have all the photographs there. Officer Gasson is now stating, well, I guess I couldn't see some of them all. In fact, he even saw new ones that occurred. He took photographs on February 7th. Again, they certainly would have been visible on January 10th had they not been recently dumped. So I'm just saying that my client's property is subject to having property on it dumped. If you look at the shed without a roof that has a photograph of tires, those would have been visible on December 22nd had they been there on December 22nd. Ms. Anexi has gone to the trouble to have her maintenance man remove all the junk that she periodically finds has been dumped on her property. I'm suggesting that at most the property could have been in violation through Ms. Anexi's ownership through the end of December 2017 when she had the invoice for the trees sustained and removed, and she paid $3,000. Now, the other violations were new violations that we just we'll just add it on, we'll just add it on, and we won't even notify you of any new alleged violations. We'll just say, you're not in compliance, you're not in compliance. We've got new violations that are occurring that we have, that I suggest we have proven to have established after the alleged code date violation. When Mrs. Annexi called the city, and that record is already in, I think it was like January 4th or 5th, she called the city and asked to have it re-inspected. The property was compliant. When the guy went out on the 10th to re-inspect, he noticed some other violations that were there and they were dumped. And the gentleman, Chris Conrad, cleaned them up. And you know, every time a person dumps something on a person's property, that doesn't create a violation. It's not creating a nuisance because none of the property has been, adjacent property is in any way, shape, or form affected. So I'm suggesting to you that through January 5th, you could find a repeat violation that occurred, but all the other violations, which we're not dealing with an amended violation. We're dealing with the original violation that occurred as cited back in December of 2017. And I would say since the trees or the pepper trees are off the charges, that property's been cleaned up as she's indicated by her invoice on how much she's paying, plus she's paying Chris to clean up even what dumpers put there. So I'm suggesting that the city could find a repeat violation through January 5th, but not for dumping that has occurred and has been cleaned up by Ms. Annexi's maintenance people anyway. Thank you.
Yeah, so now you'd close the public portion of the meeting and consider a motion. One thing I wanted to tell you about the law before we do that. Mr. Rock incorrectly cited the law relative to repeat violation. Under Florida statute and under the city's code, especially code section 2-160, a repeat violation, I'm just going to read the definition, a violation of a provision of a code or ordinance by a person whom the board has previously found to have violated the same provision within 5 years prior to the violation. There's no requirement to be associated with any particular property. It's the person and the code. If the two of those are the same and it happens within 5 years, it's a repeat violation. So there has to be no connection to a specific piece of property. So I wanted to make that clear as to the definition, and that's the definition that mirrors the definition in the statute. Okay, so I'm sorry.
That's okay. So we need a motion under
Make
the
a motion.
repeat violation.
I'd like to make the motion. I move that based on the testimony, evidence, facts presented in law, that the Annexity Group LLC was in violation of sections 8-40 and 8-52 of the Tarpon Springs City Code from the initial date of 12/22/2017 until the compliance date of 3/5/2018, and a fine of $100 per day for 73 days, total fine of $7,300. In addition, I move the city be awarded $123.50 for the costs incurred in prosecuting the case.
Do we have a second?
Yeah, I second.
Any discussion? Okay, roll call.
Roll call. Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Dabbs,
Yes.
Mrs. Archer.
Yes.
Motion carries.
Okay, we can move on to the next case then. Yeah, so you can read that.
Repeat violator, in violation from 1/16/2018 to 2/19/2018 for 34 days. Case number 18-800000032 at 544 Grand Boulevard, the Annexi Group LLC.
There's photographs. I have photographs.
Okay. Sister Rock, do you have any objection to the photographs and evidence that's being presented by the city on this particular case? Oh, gotcha.
No, sir.
Hey, Bobby, would you please accept these photos and evidence?
Yes, ma'am, I will.
Okay.
This is case number 18-800000032. The property address is 544 Grand Boulevard, owned by the Annexi Group LLC. As stated, it was a repeat violator case out of compliance from January 16th, 2018 to February 19th, 2018 for a total of 34 days. It's a repeat violator under case number 15-391 for violation of 8-40, repeat violator of 17-481, 8-40, and a repeat violator of under case 17-618, which was a violation of 8-52. So the repeat violator status is for 840 and 852. Exhibit number 1 are all the photographs to include the inspections. All notices to include the notice of violation and notice of hearing are exhibit number 2. Exhibit number 3 are my administrative docs, case summary, property appraiser and tax collector records, as well as any officer emails. Exhibit number 4 is an affidavit of posting and a copy of the sign. And exhibit number 5 is an affidavit of the prosecution costs. All of the photographs and exhibits that were given to the violator are exact copies of what's being presented to this board. All of my notices were mailed to the property owner of record as determined by the Pinellas County Property Appraiser and Tax Collectors Database. And Madam Chairman, I believe you already have, but please accept all these into the record as evidence. This case started January 16th, 2018. My initial inspection was a result of being called to the property across the street for a complaint, and I noticed violations on this property subsequent to that. I noticed there were 3 boats on the property that appeared inoperative and unused. There was 1 old RV, which also appears unused, and a jet ski, which appears unused. This is residential property. Also, the front window is broken and needs to be replaced. On January 16, 2018, I had personal contact with the tenant and spoke to him about what the violations were on the property. And the same date, the repeat violator notice of hearing was mailed, certified as well as first class. On January 19th, we received a phone call requesting pictures of the property for 439 Lemon Street, and this property to be picked up by our attorney. On January 26th, the sign was posted and an affidavit of posting was signed. January 26th, we received a phone call from Mary asking what the problem with the van or the RV was because it is licensed and tagged. I emailed Officer Gasson with a question. He called back letting her know that what the problem was. As I've discussed numerous times, the definition of debris is unused equipment, which also includes motor vehicles. So that was the ordinance that was cited. On February 9th, we got a deferral notice because, as the other case I stated, we continued it until this code board. February 14th, we had our office called Mary Nexie, reminder that Winnebago was the only violation left. They had taken care of the boats. 2 of them were removed. One of them was currently tagged. He put air in the tires, and he being the tenant, states that he does use that boat. So it no longer appears to be unused based on all of those circumstances. I got a call on February 16th, a phone call from the owner of the Winnebago. He has a plan to get the violations corrected. He admits it won't start, it won't run, it hasn't been used for a period of time. Basically, all he had to do is remove it from the property for it to be in compliance under that definition. He's stating it was removed on February 19th when we received a phone call. On the 20th, I conducted a reinspection on February 22nd, and the RV was removed, and so the property was placed into compliance. And it was placed into compliance, as I stated, based on the date we were told the RV was removed. So the benefit went to them on February 19th. Posted the property on March 31st, and then we got the continuance request. I then posted the property again for the deferral for this today. And so needless to say, we've had numerous contact. All the violations are currently complied. They were out of compliance for a period of 34 days, as I stated, from January 16th to February 19th. and they deal with 8-40 and 8-52. And at this point, that's all I have.
Okay, does the board have any questions for Officer Gasson? Okay, if not, do you have any questions?
Thank you. Officer Gasson, did you find out that that property, particularly the boats, had not been abandoned? That they were just, the titles were reinstated and the tags were put on?
I wasn't approaching them from an abandoned aspect. I was approaching them from an unused aspect. They have flat tires on the trailer, kind of hard to use.
Well, if, Officer Gasson,
Mhm.
Have you ever seen a flat tire on a car before?
Yes, sir.
Does that mean the car is abandoned or it has a flat tire?
Could be both, especially under our ordinance.
Did you have any conversation with the owner, or the tenant, I should say, the tenant concerning the existence of a cracked window and a board?
Yeah, I believe I did.
And did you take any photographs of the window with the board?
Let me look through my photographs because I believe I took a picture of the front window. Yes, I did.
And didn't you have to enter the property to take that picture?
No, I didn't. And the upside to this is there's a beautiful thing on my camera called Zoom. So I can stand at the entrance where the sidewalk is in between the bushes on the city sidewalk, and I can zoom in and take a great picture of the front of it without entering. But with that being said, I met with the tenant while I was there, and he brought me around to the side to talk about the boat. So
that's how you had access to take a photograph?
No. I took that photograph from the sidewalk, as I stated.
Through the trees?
Well, there's an opening you walk through to go to the front door. It's to the right of the front door. This is the front of the house.
Did the owner of the property tell you why he put the board up for hurricane?
Mary.
No. The tenant tell you why he put the board up?
I don't recall. I don't know if he did or not.
Did you find out back in February that the boat had been repaired and the window had been repaired in February of 2018?
Well, I put it in compliance on the 19th, so sure. February of 2018, it was repaired and in compliance.
Are you aware that the boat was updated, registration and compliance on February 8th, 2006?
Yeah, I stated that. So
the only reason for the additional 10 days, in your opinion, or 11 days, is because of the Winnebago in the back?
Well, that's true because it was in violation, correct?
Did you make an inspection of the window to determine whether or not it was caulked or not?
No, sir, I didn't because I didn't go up to the window. I took the picture from the sidewalk.
It's cute.
Crickets.
My witnesses aren't the only guys that have that problem.
That means you have to bring the donuts next time.
Sorry, I had it turned off.
Any more questions?
I have no further questions.
Want to state your case now?
Officer Gasson, I'm going to hand you some photographs, images of paid registration, motor vehicle tag, and window repair through exhibits 1 through 5.
No objection.
All right.
Okay. So
I'd call
there's
Mr.
no
Morphy.
objection. He's propping them.
I'd like to introduce them as a witness.
Yeah. Yeah.
Bobby, would you please accept these photographs into evidence?
I'm sorry, Officer Gasson, I forgot what your response was. Did the tenant ever tell you why he put the board up on the window?
Yeah, I responded. I don't recall.
Now, is it your understanding that the window was installed improperly or had been broken and needed to be repaired?
I have no idea. It was a broken window.
Well,
And how it happened and how it got fixed, I was just happy it was fixed.
well, the code talks about having a window improperly glazed, but you indicated that you didn't see whether it was properly glazed or not.
I didn't charge him under IPMC.
Excuse me?
I didn't charge him under IPMC. So it's a moot point. I could make life easy and we could take the window completely off of here and just discuss 852 if you want. And we don't have to
That
discuss
would be
the window.
fine.
Okay. We won't discuss the window anymore.
Thank you. Wait a minute. I don't have any other questions. We'll accept the 852 being off and we're just under 840.
No, it's the other way. We're
I'm
just
sorry.
talking 852.
So you've got an exhibit number 11. You haven't tendered an exhibit number 11 yet. Do you want that in?
Did I see it? I think he just dropped the charge, so it probably won't be relevant.
Okay.
We can proffer it. Just shows that the window is fixed.
All right, you can hand it back. No, thank you. Those are the 5 that have been received.
Yeah, 11 relates to the window.
Okay.
Sorry. I have no further questions.
Do you have anything you want to state?
Pardon me?
Any witnesses?
Oh, yes. No, I take that back because he's already removed the window. Just Mr. Gasson.
Sure.
In your opinion, did the vehicles that you photographed or imaged either increase or decrease the value of the property in the neighborhood?
I took 840 off of the table. So it's irrelevant.
You were just under the motor vehicles, correct?
We're just dealing with 852 debris.
And the debris would be the motor vehicle?
Would you like me to read it to you? Because we've had a lot of discussion about, there seems to be some issues with
Well,
what the definition of
it
debris
might
is.
take you a little less time to find it than to me to go through it.
I have it right here in front of me.
Okay, would you read it?
The definition shall include but not limited to one or more of the following: discarded household items, inoperative or abandoned machinery, motor vehicles, boats, trailers, or household appliances. If you want, I can go through all the including but not limited to, which doesn't cover anything else. So in sum and substance, the abandoned machinery, inoperative, not operating, motor vehicles, boats, and trailers. So that's under the definition of 852. That's actually 851. That's the definition of debris, and 852 refers to 851.
All right, sir. So the RV and the supposed abandoned jet ski or inoperable jet ski.
Inoperative jet ski, 2 other boats which were removed. The third boat, which I have no argument with, was registered February 8th, I believe.
Yes,
And
sir.
then the RV was finally made to run because he couldn't get it running for a couple of days. Called us a few times, told us he's having a hard time getting it started. Finally got it out of there February 19th.
Did you determine whether or not it was delinquent in its registration?
It's a moot point. It's not covered under that debris ordinance. It's inoperative, and that's what I went with.
Well, that
I
would
didn't
make-
charge him under 40.00.
Would that make any vehicle that is not or is in need of repair inoperable?
Depends on the circumstances. I think one that has mold growing on it, the grass has grown up underneath of it, and the argument of the owner that it took him 2 weeks to get it started kind of goes that route.
Would you please show me a photograph of what you're talking about? Mold
I don't
and
have one
green-
with me. I don't have one of the RV because
Oh,
I saw
okay.
it from the street. And I've been on that property numerous times. We've had calls for service there. So between her place on the backside off of Ada Street, which I think is 26 Ada Street, we've had numerous calls for service. We've been backing through there. That RV's been there for, I know for a fact, greater than 1 year.
And
And
for
hasn't
some
moved.
reason, you didn't take any images of it to reflect the condition that you say
I couldn't
existed.
get a decent picture of it because I could see it from Ada Street, and there's just times where you don't. But,
But your telephoto wasn't working?
well, actually, when you use a telephoto lens, because as we've stated as a photographer, you get all of the branches right in your face. So the picture's no good at that point.
I have no further questions.
Oh, hold on a second. That's the third time you've told us that. So.
Further evidence?
Okay. All right. So you have any witnesses, Mr. Rock?
No.
You're not going to call Ms. Annexi?
I'll call Ms. Annexi. State your name, please.
Marion Exie.
Mary, did you have a tenant repair a window, which is not, I'll withdraw that, remove vehicles or get them up to registration?
The big RV that was there was from Andy, who had a very bad heart attack. He was my tenant for maybe like 8 years, 9 years. And he had moved to the West, no, I think it's the West Coast, I'm not sure, by Daytona. And he was coming back to fix it. And I said, no problem, just come as soon as you can because we need to, get it. I didn't have key or anything to it. And
Was it at all visible from the street?
no, it was parked in back of the house. Well,
Was it an eyesore to the neighborhood?
no, it was in the back middle of the property next to the big structure, the glass lady, Robin Singer Milo, the glass little factory she has there, stained glass. And it was like in the 3/4 up the property and back of the blue house on Grand. And people could get by and, go with the cars from street to street, no problem.
So the tenant has, and/or the owners of the vehicles have removed them?
Yeah, he came from the West Coast. He was sick, and Andy is a very fine man. He was an excellent tenant, a very nice young man, and he took it. He got it out of there. I didn't want to take somebody's property,
Now am I supposed to ask you?
Board question.
Does the board have any questions for Ms. Annexi?
Cross-examination.
Do you have any questions?
I have one. How long was that RV there on your property? Did you?
When Andy left, I don't recall. Not that long.
More than a year?
I don't think a year. No.
Okay. Did you earlier state he got sick and he
was-
had been a tenant for how many years?
For many years, he used to live there.
Okay, but you don't recall when he left.
Oh, he left maybe a few months before that vehicle. He got sick when he had to go visit. Not his mother, his brother. I don't know, somebody on the West Coast. Then he ended up staying there by Daytona. I'm not sure where it is.
Okay.
I have his phone number at the house. In my book. I don't have it here.
So you don't know how long it had been there?
In Daytona?
No, the RV, the Winnebago.
Oh, not that. I don't.
I have nothing further.
Not that long though.
Okay.
Since he left.
Officer Gasson, would you like to summarize?
Briefly. Basically, like I stated, I did the inspection. There was the jet ski that was inoperative, which is defined as debris. It was moved. 2 of the boats were removed. And then the bigger boat, he got back into a working condition because we discussed that. The RV obviously was inoperative because it took a significant amount of work to get it running, to get it off of the property. So it fell well into the definition of a debris under 851. So for the period of time from January 16th to February 19th, for the 34 days, the RV was there. It was inoperative. It is defined as debris. As far as all the other vehicles and everything, I have no contention that they were registered. They were removed. The big boat, he put tags on, he aired up the tires, he cleaned it up. He said he was going to go out and use it. So at that point in time, it's not abandoned. It's not inoperative because he's using it. The other ones were gone. I don't know at what time they were gone, but it's a moot point. They're gone. So we were dealing with the RV still being there. And as I stated, it took a significant amount of work per the owner because we got numerous phone calls from him to get that thing running and get it out of there. Must have been an issue because we got it out of there once we sent the notice. So that's all I have at this time.
You have anything to summarize, Mr. Brock? Okay, so, public portion of this case is now closed, and we will entertain a motion under the repeat violation.
Yeah, I'll make that motion too, if you'd like. I move that based on the testimony, evidence, fact presented in law, that, the Anixity Group LLC was in violation of sections 8-40 and 8-52.
No, he took 8-40 off the table, so.
Oh, I'm sorry.
And they both agreed to that.
Okay.
So that's
Okay.
not part of this motion.
I will repeat, what was in violation of 8-52 of the Tarpon Springs City Code, from the date from 1/16/2018 until 2/19/2018, and a fine of $100 per day for 34 days, or a total fine of $3,400. In addition, I move the city be awarded $76.50 for the costs incurred in prosecuting the case.
Have a second?
Never seen
I second.
thieves. I'm getting
Any discussion?
gonna deal with these people anymore.
No. No, we're not taking any testimony from someone in the audience.
Yeah, we close the public portion.
Just wants to tell them something.
Okay, roll call, please.
Yes. Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Archer.
Yes.
Okay,
That's part of it.
so we can move on to the affidavits of non-compliance.
Wrong.
Oh.
We need to find out whether anybody is in the audience for this one, though.
Yeah, case number 17-8000734 at 1330 Belcher Drive, USA Federal National Meeting? Mortgage Association. Is anyone here from there for that case?
Okay, good, thank you. So we can do a motion to accept.
I'll do it, if you'd like.
Yes, please.
I move based on testimony, evidence, and facts presented on the law that the respondent failed to timely comply with the board's prior order within the time prescribed, and award the city $128 for costs incurred in prosecuting this case.
Second?
Second.
Any discussion? We need a roll call.
No, you all.
Okay. All in favor, say aye.
Aye.
Aye. Any opposed?
You saw the first two have no cost and the last two have costs on the affidavits of compliance.
You can do those two then, right? First?
Yes.
Clients?
You do those first two first. No. There's no cost.
There's no prosecution costs in cases under
Correct.
agenda items 16 and 17. You could read those together.
Yes, all right. I move we accept affidavits of compliance in 08-800000157, and in case 17-800000624.
Need a second?
Any second?
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed?
I move we accept the affidavit of compliance and to award this, you want to do the case first?
You gotta read the
Case number, that's what you've been doing.
Yes. That's correct, yes.
Go ahead.
Okay, I'll do it if you want, I don't care. Case number 18-8000001. I move to accept the affidavit of compliance and award the city $167.50 for the costs incurred in prosecuting the case.
Do we have a second?
Second.
All in favor?
Aye.
Aye. Any opposed?
case 18-800000005. I move we accept the affidavit of compliance and award the city $113 for the costs it incurred in prosecuting the case.
Do I have a second?
Second.
Any discussion? All in favor, say aye.
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 Opposed? Carried. Okay. Oh. We have old business, fine reduction request. Case number 08-800000157 at 1615 Seabreeze Drive, ERC Homes Capital LLC. And then the previous owner was Asset Recovery 23 LLC. Is there anyone present?
Someone is here.
Yeah, this gentleman over
If
here.
you'd like to come up to the table, in case anyone has any questions.
I don't have any paperwork on that, do you guys?
Here you go.
Okay.
He doesn't need to be sworn in.
No, just have a seat.
If we have questions of him, we'll swear him in.
Find it.
It's the big pack.
This
That's
one?
it. That's it.
Ooh.
Has the board had an opportunity to read the petition? Okay, we're ready to entertain a motion.
I move that we decline to accept the request for fine reduction.
Do you have a second?
There was a motion to deny the request.
Do we have a second?
Yeah, I second.
Okay, any discussion?
Yeah. I just, wow, this is serious. I don't even know what to say. This is a huge fine, and it's I believe what they wrote to us. I don't see it necessarily it meets our criteria that there's a hardship, except they probably can't develop the property, is what they're saying. So that may well be classified as a hardship. I mean, that's a huge fine that was there from a previous owner. I understand they get it, they buy the property. I don't know. Yeah, I know all the rules, what they should have done, but, I don't know. Me personally, I feel like I'm a helper on this board. I'm trying to help people, not kill them. You know, I don't know. It's just my opinion.
I have a question, but I don't know
The only way
who
you
to.
can reduce the fine is if it's a hardship. That's the law.
I know.
That's your rule. Right.
I know.
Can I ask?
I know.
Are you going to ask him of this man here? Or do you want to ask it of me? What
Of
would-
you, I think.
Okay.
Don't liens supposed to be satisfied before selling the property?
No. The buyer can buy it subject to the liens, and then they try to negotiate a deal with the city, and that happens every single day. And so that is evidently what is happening here. Because if this property owner bought the property, they would have done a title search and they would have seen the lien. So they're basically, pleading to you. And I would remind you that, I'll just read the rule to you so that everybody understands the rule again.
Yes.
Because I think that would be helpful. And I'm reading from your rules that have been in effect for 25 years. After a fine, it's Rule 5, Section 4, after a fine has been imposed by the board and within 60 days after the violation is brought into compliance, a violator may petition for reconsideration of a fine. The petition must be in writing, signed by the violator, and include a copy of the affidavit of compliance executed by the code inspector. The petition must include conclusive evidence showing extreme or undue hardship in the payment of the fine and preventing the violator to come into compliance within a time period established by the board's order. The board secretary shall schedule the petition to be considered, and the board shall make its determination based solely upon the written petition. The board may request information from the code inspector. The board secretary shall notify the violator by regular mail of the determination made by the board. No petition for the reduction of a fine will be considered prior to the board's acceptance of an affidavit of compliance, which you did today, by the way. Under no circumstances may the amount of the fine be reduced below the cost of the action. Under no circumstances may the amount of the fine be reduced once a foreclosure action is instituted. Additionally, under no circumstances may the amount of the fine for a repeat violation be reduced.
And we've had,
Do they have another route to get this fine reduced?
Yes.
They can appeal this to the city?
What normally happens is there would be an offer of settlement, and it would come to the city attorney's office, and the city attorney's office would make a recommendation based upon discussion with city staff as to what we believe would be a reasonable settlement. And if the city commission authorizes the settlement, then it would be reduced based upon that offer of settlement.
Thank you.
So there is another avenue.
Thank you.
Okay.
so we've had a motion and a second, right?
Yes, you have.
Any more discussion? Okay, roll call, please.
Ms. Norfleet,
Yes.
Mr. Robinson?
Yes.
Mr. Kramer?
Yes.
Ms. Wade?
Yes.
Mrs. Archer?
Yes.
Sorry, but you do have another way to go around.
Can you, did we make note when Mrs. Dabbs left?
Yes, I did.
Okay,
Yes, sure did.
all right.
Wow. I was painful.
I know. He can fix it.
Okay, another fine reduction request, case number 16-800000121 at 832 Lincoln Avenue, Lincoln Street Land Trust, number 202.
Looks like there's somebody here for this
Donor?
case too. Okay.
You just want to have a seat there in case anyone has any questions? Okay. You had a chance to read it over?
Yeah, I haven't. I guess I had it at home and I looked at it briefly, but I need to
Here's another one.
look at it again. Thank you.
We ready for a motion?
Calling for motion.
Yes. No.
I move that we decline the request for reduction of fines in this case.
We have a second?
Do I need to give the case number?
No, the case was called.
Okay.
Do we have a second?
Yeah, I'll second it.
Okay, any discussion? Or questions? Okay, roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Archer.
Yes. Okay, another fine reduction
Oh.
request. Case number 17-800000234 at 418 South Levis Avenue, Emma Scott Murray.
I move that the fine of
I don't have that one either.
Fine, $11,800.
the fine of $11,800 be removed in this case, and that she does still, the fine reduction will occur on payment of the stated reduced amount if paid within 60 days of this order. Failing to pay, the reduced fine will revert back to its original amount of $11,000. But I don't know how to keep the,
What are you reducing it to?
If you reduce it to 0, there's no payment due, so it would just be a motion to reduce it from the current amount of $11,800, I think this is what Bobby has told us, to 0, and then nothing else needs to be included in the motion.
the prosecution costs still remain, because we can't take those off.
If you want the prosecution cost to remain, you need to make that clear in your motion.
Okay, that's,
Is that your motion?
I'm gonna restate the motion.
Okay.
I move that the fine of $11,800 in case number 17-8000234 be reduced to $800. This fine reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failing to pay, the reduced fine will revert back to the original amount of $11,800.
Second.
Prosecution costs
Okay.
will remain.
Second.
Wait a minute. Didn't they recommend?
Those costs were $290.00.
Okay. They did, but the motion was to only reduce it to 800, so they're not following the city's recommendation.
Not quite.
Yep. And that's obviously your prerogative, so.
Discussion, right?
Yes.
Do we have a second?
Yes, you did, Mr. Kramer.
Is there any discussion? Okay, I just want to say I don't go along with it, but, you know, the vote will tell. I do have a question about the date of compliance on here. It says 3/28/17. Did you mean 18?
You can answer.
It's 2018.
Yeah, I was being nice.
Okay.
Or Beth was being nice, and she's got.
Any other discussion? Roll call.
Ms. Norfleet,
Yes.
Mr. Robinson,
Yes.
Mr. Kramer,
Yes.
Ms. Wade,
Yes.
Mrs. Archer.
No.
Okay.
So we have
We have the approval of minutes.
Do we have minutes?
We don't have
We
any,
don't
I
have
don't
minutes,
think.
do we?
No, ma'am.
There's no one in the public.
Okay. Public comments? City, have any
I'm
comment?
not, I'm done.
Can I have a minute of your time? I want to, okay, thank you. I wanted to explain to you this order that I handed out to everyone today on your desk. I wanted you to understand what is happening. Ms. Annexi, through her lawyer, filed a lawsuit against the city of Tarpon Springs alleging failure to produce public records and also failure to allow him some discovery. And in the code enforcement cases you've already heard today, they had specifically asked to take the deposition of Officer Gasson. I've told Mr. Rock that he has no legal right to take the deposition of Mr. Gasson, and he immediately filed a lawsuit against the city. Because of the fact that there's allegations that public records have not been provided, the case is sped up very quickly, and that's what happened here. Within the last week or so, 10 days, there was a hearing before the judge in the case. Each side had filed motions for summary judgment asking the court to enter a judgment in their favor. And this 14 or 15 page long order basically says the city was absolutely right in not producing the documents because of the fact that Mr. Rock's client failed to pay for the production of those documents. And the city was absolutely correct in not allowing Mr. Gasson's deposition to be taken because it's not provided for under the law. So it was a complete win for the city. I'm very proud of my associate Robert Eschenfelder and my partner Jay Daniel for handling this thing so quickly in the last couple of weeks. They did an excellent job. But that's what this order is on your desk for, to let you know that the city the city did prevail. More than likely, the case is going to be appealed. If it is appealed, we're going to be handling that too, and I'll bring you back updates to let you know what is happening in that. But it's an interesting read if you
It was interesting.
take the time to do it. And if you have any questions about it after you've read it in its entirety, I'd be happy to answer them for you. So
Can I get a copy?
You can have this.
They thought I wasn't
Yeah,
going to be here, so.
yes, I have a bunch of copies.
I have it on PDF.
Our ability to serve on this board was also questioned.
He did not file a lawsuit against the city saying that this code enforcement board did not have the authority to hear cases. But I will tell you the statute is very, very clear, and that says it's whenever possible to have seats filled by people with particular professional backgrounds. And, that would be great in a perfect scenario. But what happens here is that people that want to volunteer their time, like the 7 of you, you may not necessarily have that background. And I can tell you in my almost 30 years of doing this, I've never seen a city have that set up in their code enforcement board, even though the statute says that that's what it's supposed to be. So that's why that language is in there whenever possible. So you guys you're doing a great job, and don't be concerned when people or lawyers attempt these little legal maneuvers to discredit what you're doing and your qualifications. You're absolutely qualified to be here.
As long as you're here, he's not even scary.
Well, so.
Oh, okay. I would like to say something. You can leave. Last month, a violator's attorney asked that this code enforcement board be disqualified because there wasn't an architect, an engineer, a general contractor on the board. Sitting on this board for as long as some of us have, I've realized that common sense goes a long way. We are all volunteers, chosen by our Tarpon Springs City Commissioners. We do not get paid. We obey the law. We know right from wrong. And we do our very best to address these violations and make a determination that is right for all, because we want to make a difference for our city. Wanted to get that out.
Right.
Does anybody else have anything else?
Right.
Okay, I adjourn this meeting at 5:14.
Thank you. Wow, beautiful.